Or may I be permitted to mention about the extension of interim order?
Yes.
My item appearing is item number 129 of the.
Will appear as extension for extension. Opor diye deben for extension of interim.
Maybe.
Ah.
Maybe.
Yes, yes.
I have served the.
For inclusion in the daily list.
Switch the microphone on.
Mentioning for inclusion in the daily list.
What is the matter?
Arising from matrimonial.
Is it an application
Yes.
or a hearing?
Application.
Yes.
This is an application order 41.
Application, yes.
Yes.
May I be permitted?
No, Mr. Shaw is there. Yes.
I have got a humble prayer subject to lordship consider. I am praying for accommodation. Item 16. If your lordship
16.
16. Lord, I have taken consent. If your lordship direct man, take up at 20.
Mr. Shaw, when the matter is called on, keep somebody, let him ask for that and we'll do it. When it is called on, yes. Yes.
For inclusion.
What?
Up to application are pending on for consideration of delay. And
Applications?
Application.
Yes. Yes.
May I be permitted to mention two matters? Both are Order 41 Rule 11.
Yes.
May I be permitted to mention an application for restoration?
Application, yes.
Lord, order 41 application.
Permit to mention lordship for admission.
Can't hear you.
May I permit to mention your lordship?
Switch the microphone on. এই মাইক্রোফোনটা একটু দেখিয়ে নেবেন, ওটা কয়েকদিন ধরে এটা চলছে, আজকে রিসেসের মধ্যে দেখিয়ে নেবেন।
May I permit to mention your lordship for admission, your lordship?
Yes. Yes.
May I permit to mention this for inclusion application matter, my lord?
Hand over. If it, sir, please. ওটা সাইড করে দিন, দিতে হবে না লিস্টে। এফিট এবার অ্যাডমিশন কি কোন অ্যাপ্লিকেশন আছে হচ্ছে দেখে নিন। না 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 জেনে মিনিমাম মেনশন কর। ইয়েস কলম দেন। ইয়েস এটা কি জন্য? We directed you to put in requisites. You had put in requisites.
And they have also issued the notice. Officers also issued the notice.
So no further order need to be passed then. It transpires that postal costs have already been deposited by the appellant and notice has been issued. So accordingly, no further order need to be passed in the matter. Thank you. হ্যাঁ ওদের উপরে সার্ভ দিয়েছে, সার্ভ করে দিয়েছে। 26 সিরিজ।
My lord, I am for the respondent claimant, my lord. In this matter, under Workman Compensation Act, appeal under at the time of listing, this honorable court has determination. Now at the present,
We don't have determination.
I'm for that.
Not employee state insurance. আচ্ছা।
employee insurance.
This is an employee.
This is the Employees Compensation.
Workmen Compensation Act is a different act from employees. This is an Workmen Compensation Act. Learn it. You are for the respondents.
Respondent claimant.
I'm for that.
So this we don't have determination. It is pointed out by learned counsel for the parties that this court does not have determination at the present juncture to take up the appeal. Accordingly, let the matter go out of the list with liberty to the parties to mention before the appropriate bench having determination. Thank you. কি কথা বলে গেছে একটু মনে করিয়ে দিন, সেটাই তো মনে করবার জন্য আপনাকে। কথা বলে গেছে তো অনেক কথাই বলে গেছে, আপনাকে তো বলে দিতে বলেছিলাম যে মনে করে দিতে। It was directed by the order dated February 10, 2025, that the trial court records be brought by special messenger at the cost of the appellants. However, it transpires from the report of the SR section dated February 7, 2025, that the certified copy of the decree is required to be sent down for necessary insertion regarding valuation statement. Accordingly, the certified copy of the trial court's decree be sent down immediately to the court below, to the trial court, for the purpose of insertion of the valuation statement therein. It is made clear that only upon such certified copy being sent down and the correction being done, the records, along with the said certified copy shall be sent to this court. ওটা আমরা রেকর্ড দেখেছিলাম, কিন্তু সার্টিফিকেট করতে ভুলে আবার যাবে কারেকশন করতে। আগে সার্টিফিকেট করতে গিয়ে কারেকশন করে আসবে।
I am for the petition where
Yes. What is the matter?
petition. And APD service is already been affirmed, but some defective. So further affirmation sent for affirmation.
What
This
has been
put
affirmed? What has been affirmed?
affidavit service. But already have served and
It's appearing for quite some long time.
yes, ma'am. There is one for substitution and condonation of delay. Delay, it is a actual delay is more than 8 years, but I have substitution.
Copy has been served, proper copy has been served.
Copy has been served, but
We'll take it up at 2 p.m. then?
no, but one
On the
One
prayer
day.
of the appellants, the matter is adjourned for the day.
tomorrow I shall difficult matter thereafter tomorrow.
On the prayer of the appellant, the matter is adjourned till February 24, 2025. হ্যাঁ ওইগুলোই।
Lord, I wish to appear for the appellant in this matter.
Yes. What is the application about, Mr. Kormakar?
No, this application was filed for injunction.
Appeal is against?
Granted.
Acha, appeal is against what?
Lord, appeal is against Lord dismissal of my suit, Lord, for declaration of tenancy right. Lord, their injunction was granted with the order dated Lord 25th of October 2017. Your Lordship had seen that on the last occasion. Last paragraph of that order, Lord, may I place it for your Lordship,
Yes.
Lord? The defendant is restrained from disturbing possession of the plaintiff in the suit premises and/or right of the plaintiff's ingress egress through the common passage to and from the suit premises till disposal of the application.
Suit
So,
were
but-
dismissed by holding that you are not a tenant.
Yes, I was declared to hold. I was held to be a licensee.
License, no counterclaim filed.
No counterclaim filed, but subsequently a suit for eviction has been filed. Not that I am contesting,
That is pending.
but that is pending. Now, my lord, in the meantime, what has happened is, my lord, there were two aspects of this order. One is my possession would not be disturbed. The second is, my lord, ingress and egress. Now, my lord, in the garb of repairs, my lord, your lordship knows, my lord, the Grand Hotel is being repaired, my lord, for their internal purpose or whatever it is. My lord, in the garb of that repairs, my lord, the in my electric connection has been disconnected, my lord, the water connection is being disrupted. My lord, all these problems are being created. We have written to them. Lord, I find, Lord, that's completely against the spirit of this order. Lord, in a circuitous manner, Lord, this order will be rendered.
The injunction is subsisting. The
Subsisting.
injunction application has been disposed of.
No, it's pending.
Well, I'll tell you the difficulty we are facing.
Yes.
Now, this hotel, the Oberoi, the property that is in Oberoi. Now, this shop was inside the hotel.
It is not in the arcade. Now there are 2-3 shops along with it. Now we have closed down the entire hotel from 15th of August. There's no more operations. So it's an absolute renovation going on in the hotel. Now for that reason, we have dismantled all structures, electricities, the air conditioned duct, everything has been dismantled. This we have informed them on 14th August that I am informing you, and there are
But there is a
2-3
specific order in the teeth of that order.
I
How
know,
can it?
but they are enjoying the property. It's not that I'm stopping them.
No, you're disturbing the possession by disconnecting electricity.
That the difficulty is, Manoj, to disconnect the electricity, I cannot today.
Possession does not mean physical possession only. It has to be a possession of dignity.
Their men are entering the premises.
Ingress,
We are not
egress,
stopping
very
them.
well, we
Yes, they are
understand.
not. But
Electricity?
electricity, my lord, electricity, we don't have electricity today because the electricity to the hotel has been dismantled. The server, everything. Only we have electricity for this masonry work. But he requires a air condition because that was through the common duct. The entire common duct has been
But
dismantled.
you should have taken leave from the court.
I
before
know,
doing
my
it.
lord.
This is a violation of the
I
statute.
know. I did yesterday only.
No, then why are you arguing?
No. The difficulty is, my lord, we came in the picture last week only. The new
Really?
setup. I know. I am aware of this. We should have approved.
But unless you have taken, you are guilty of contempt. Then why shouldn't you issue so much rule of
It is
contempt?
not that, my lord. They should then.
They should have taken a one-line leave from the court.
But today, my lord,
Alternative arrangements have to be made by you for them.
my lord, there is
regarding electricity
there
also.
is nothing on record. Let them put something on record that I am disturbing them, or I am not giving
No,
electricity.
you are admitting that in your
But
argument.
electricity is that if they want a LED, small LED, that is done. But in generally, what is to
No,
happen?
don't give it from the central duct. They have to have sufficient electricity power to run their AC and whatever.
No, they didn't have an air condition
it's a
independent.
jewelry shop.
Now, my lord, the jewelry.
Well, did not have. If you have disconnected whatever they had, you have to supply the alternative.
What I have instructed, the shop
Sorry.
is no more running. They have removed everything because it is not the public who is to go as a customer. It's only my guests who have access to the shop because this shop has no exit on the footpath. The customers are only through my lobby.
But if they have possession, if the shop is
They have possession. They have possession. The 1 or 2 staffs are
you
going.
have to use because you have disconnected electricity.
No, my lord,
How will
only-
they run the shop?
Let them put something on record because there are documents. There are 3-4
Very well.
letters
But if my
exchanged between
learned
them.
senior friend wants that, I shall come up with a
Yes,
contempt application.
No,
Yes, I'll come up with a contempt
No,
application.
you have to allege in the first place that they're disturbing you.
Yes,
I can come up either with a contempt application or file a supplementary affidavit to this.
Lord,
Because injunction application is still pending. You can
Yes.
file a supplementary affidavit. They'll use an opposition to that.
very.
Learned counsel for the petitioner argues that the respondent opposite party, in the teeth of the order dated October 25, 2017, restraining the respondent from disturbing the possession of the plaintiff stroke appellant in the suit premises, have disconnected amenities to the suit shop room, as such violating the order of injunction. Whose of next para, learned counsel appearing for the respondent contends that the respondent is in the process of dismantling the entire structure in view of subsequent developments for which the air conditioning duct through which air conditioning was being provided to the appellant and other electricity connections had to be disconnected. Whose of next para, be that as it may, the appellant is directed to bring such subsequent events on record by way of filing a supplementary affidavit with an advance copy to the respondent's advocate. The respondent, such supplementary affidavit shall be filed within a fortnight from date. Rejoinder, if any, to the supplementary affidavit shall be filed within a further fortnight. The application shall next be listed for hearing on March 24, 2025.
Lord, in the meantime, may I pray for one more thing, Lord. In the meantime, Lord, if some arrangement can be made for restoration of the
Nothing in
electricity.
this order shall prevent the respondent from exploring the option of making some alternative arrangement to restore the amenities of the appellant, if disconnected, subject to appropriate cooperation and payment, if necessary, by the appellant.
I'm great.
Great.
You sit between yourselves, your clients can sit, they will have to pay, but yes.
But it's absolutely.
So they can take a new connection, submitter, whatever. You don't know the nitty-gritties of that, so submitter.
My lordship, I'm for the appellant, my lordship.
I'm for the appellant, my lord.
Lordship, the advocate on record is out of station, his native place, because
Please use a microphone, I will
the advocate on record is out of station. in
give
his
that
native-
mic to her. And you take the other mic.
I
The-
tell your lordship, my lord.
The advocate on record is out of station in his native place as his mother is very ill. Kindly make it note today and fix the matter after 2 weeks, my lordship.
Lord, I tell your lordship, my learned friend senior, my lord, I do not know from whom Moni Shankar Chakrabarty, yes, he cannot be the advocate and record at present. This, my lord, this is an application, my lord, for restoration upon condonation of delay. It was dismissed on, my lord, 5 years back in 2020. Now, my lord, the client, when it was not informed to the client. Now, my lord, when the execution case has proceeded to substantial extent, writ of delivery of possession, client came to me, my lord, I have filed the restoration application. Now, my lord, Mr. Bandyopadhyay's my lord, Vakalatnama has expired after dismissal of the second appeal for default. Nothing was informed to us.
No, but Mr. Bhattacharya, not strictly so. If you file a restoration application, it should be filed by the previous advocate. You're seeking a restoration, his power revives.
My lord, I have given a fresh Vakalatnama, my lord.
No, you have to file a proper Vakalatnama.
Nothing was informed. My lord, when my
No,
lord,
take instruction, have a talk with Mr. Chattopadhyay if necessary.
my lord,
You can appear with him or
I have no difficulty. He is much senior to me. I have no
no,
difficulty.
you can appear with him or you can take a no objection. But as of today, you don't have any
The
locus.
problem is today is the date fixed, my lord, for my lord, belief, my lord, through police help. In the meantime, order
You should have resolved this previously. You must have known that Mr. Manishankar Chattopadhyay is vocal. That is not the correct proposition. That because the appeal was dismissed, his power ceased for that period. But the moment you file a restoration application, propriety demands that you make him. He is the advocate on record. The advocate during whose tenure the appeal was dismissed for default, he has to seek a restoration because it restores back to that position, the previous position when he had power. Your power cannot be recognized.
by him to the client. Original briefs, my lord,
You
entire
should have ensured that a no objection was given to you, the client.
subscribe, my lord, to that, my lord, no objection.
If you don't subscribe, then you can. This is a hypocrisy. This is Mr. Bhattacharya hypocrisy. In the same way, you cannot say I don't subscribe to the view that I won't take no objection, and you're appearing without somebody's no objection, although you know that he is appearing still. No.
Lord,
An adjournment of a fortnight is sought on behalf of the learned advocate for the appellant. Pushed up. However, comma, since the matter is pending in the list for some time, comma, adjourn. It is acha. However, comma, the matter is adjourned for a week from date and shall be listed next on February 24,
lordship,
2025.
my lordship.
No. In the meantime, Mr. Bhattacharya, arrange for that. Your client will be ousted from his premises and you are insisting on 2 weeks. Don't you understand? He will be on the streets. This is utter irresponsibility. If Mr. Chattopadhyay is in difficulties, he should entrust somebody else. You are taking 2 weeks sojourn for whatever reason, and the client will be on the streets. We are here for the litigants, not for you. Next. 1 week time you have given Mr. Bhattacharya, take your no objection and appear in the matter. It will appear on 24th. Yes.
My lord, the appellant, during pendency of this appeal, has transferred his right to his daughter by way of a gift deed. And for that reason, I filed a CAN 1 for an appropriate order. The name of the appellant should be Stafford, is my father. And the name of this
Have you
present-
given a notice to the other side?
Notice.
Who is appearing for the other side?
My lord, I'm checking, my lord, kindly make
The
it-
Bishwarup Bishwas names are appearing for the
My
respondent.
lord, I'm giving a fresh.
Why did you give a notice? We could have decided today. The appellant shall serve a copy of the application on the respondent and file an affidavit of service, stroke, receipt of the notice on the next returnable date. The matter shall be listed next on February 24, 2025.
I'm grateful. My lord.
If you give a notice to the advocate, then a notice, receipt of the notice. If to the client, then affidavit of service.
My lord.
Yes.
Joseph, I'm appearing for the appellant. But
Yes.
last occasion, your lordship, my lord, the deficit court fee has been, my lord, the report has been taken out. Thereafter, my lord, the section 5 application. In the section 5 application, there are some defects. My lord, petitioner wants to, my lord, file the supplementary affidavit to annexing of those documents. Kindly allow me leave to file the supplementary affidavit, serve the application section 5.
Have you served a copy of the application?
No,
have not yet
as
served.
per instruction of my as is in person, he has says the advance copy has been served without the order of the
We'll give it. A leave is granted to the appellant stroke petitioner to file a supplementary affidavit. Full stop. Such supplementary affidavit, filed today in court, be kept on record. Full stop. The appellant shall serve copies of the application and the supplementary affidavit on the respondent, indicating that the matter shall be listed in the monthly list of March 2025 under the same heading. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date. Thank you. Supplementary affidavit.
I agree with the respondent.
No reason for me to release.
No. My lord, I have 2 points for maintainability of the
Because yes. 2 points of maintainability. What is the appeal against?
But the appeal is from an interim order, my lord, passed in a Guardian and Wards Act case. Now, my lord, section 12. Now, my lord, section 47, my lord, mentions the order, my lord, from which an appeal can lie.
Final order.
Final.
Yes, Mr. Tiwari, what do you say to that?
This order was passed in the guise of allowing, in the guise of considering application under section 7. Kindly text this Guardian and Ward Act. I have only one copy.
I have another point to make before.
What is that point? Yes,
this order, my lord, which they have challenged, my lord, subsequently has been extended. So, my lord, we have a judgment of this honorable court, my lord, that the next extension should also be challenged.
That's a division bench judgment. Cite that so that Mr. Tiwari can answer. But it's an extension of the previous order. The parent order, the parent order.
It's not purely extension. I can show the order. The stay is again reimposed.
It was not there for some time.
No, that's
reimposed means if it was not there for some time, vacated or something like that,
no,
or expired, then it's reimposition. But otherwise, the language is. Anyway, let us see the very well. So you cite that judgment first.
Judgment is also. Judgment of page.
It was number FMIT
1102.
1102 2017.
Second page, will first paragraph.
Yes.
Although, my lord, this judgment, my lord, it has been referred to the larger bench, and that is pending.
This judgment, it's some other bench has referred it to larger bench.
In a civil revision or application, this judgment was cited. My lord, that has been sent to a larger.
Who referred it?
Justice Hiranma Bhattacharya.
No, there's sufficient reason for reference.
Right. 1102.
It was not held that it is not maintainable since the identity order lost its force.
Yes, lost.
How does it lose its force if it's continued? It's the same order which is extension by its very definition means something is there. Otherwise, there won't be any extension. There would be an original order.
My submission is each and every time the court is extending the interim order.
It's an exercise under that section.
It is, my lord, he's exercising its power, my lord, and giving reasons, my lord, to that. Applying its mind, my lord.
All right. Yes, deal with these points. Take your seat.
Maintainability of appeal is concerned, my lord.
First on the maintainability, then.
But this power has been exercised by, just take the facts. Facts is, the marriage took place on 6th of June, 2021.
1 second.
Yes.
Guardianship Words Act আছে কিনা দেখুন।
Marriage took place, between the petitioner and the respondent, on 6th of June, 2021. The male child was born, 21st of April, 2023. Now, the child is, as of now, 1 year, 9 months old. Now, I was compelled.
Girl or boy?
Boy. I was compelled to leave matrimonial house on 31st of October 2024. Now, I filed an application under section 97, corresponding to 100 of the BNSS, for issuance of search warrant before the learned magistrate, so that the child can be produced before the learned magistrate. Now, that application, learned magistrate passed an order.
Child was retained by the husband.
Child was retained by the husband. Now, learned magistrate passed an order for protection of the children. Now, challenging that order, he filed an application under section 7, and as well as under section 151 of the Code of Civil Procedure, challenging that order, praying for custody and stay of that order passed by the learned magistrate. Whether that application is maintainable.
No, custody is the main relief is custody.
Main relief is custody, and he is asking for the stay of operation.
That's consequential.
Consequential. Now, second, the child is 1 year and 9 months. Well, how custody can be with the
No, but first deal with the maintainability.
Maintainability point. Can you take section 47?
Yes.
Now, section 47, you will also find the orders appealable, and appeal shall lie to the High Court from an order made by the court under section 7, appointing or declaring or refusing to appoint or declare a guardian.
Yes.
Page. Yes.
Order
dated 10th of January 2025.
Oh, this was the only order which is passed.
Yes. Now, previous orders were there, but this is the order main I am challenging it. But by which
this is not a final order.
This is not a final order.
Section 25 order.
This is not a final order. I am not saying so. This is not a final order. This is
not appealable.
No, kindly see, this is this was done in exercise of power under section 7. Now, which order is appealable? That is said section 47. Now, section the interim order, the nature of the interim order described in section 12. Kindly take section 12 once. Section 12 says, power to make interlocutory order for production of a minor, interim protection of person or property.
This is interim protection of person.
Now, this is regarding interim protection of person and property. Now, power to make interlocutory order for production of minor. It says, the court may direct that the persons, if any, having custody of the minor shall produce him or cause him to be produced at such place or time and before such persons as it affords, may make such order for the temporary custody and protection of the person.
And protection of the person is
protection of the persons and the property
of
the
protection
minor.
of the person.
Now, may I submit one thing? I am willing to go to my husband. Kindly exercise your losses.
Go to your husband. Who prevents you?
Prevents me.
What can the court do?
Section 9, they file. They are not.
Go back to your husband.
Not
if you are willing, go back.
It can
Don't
be
pay lip service in a court of law.
No, it can be settled. Kindly exercise your losses, good office, so that it can be settled.
We are very bad in exercising our good office regarding matrimonial matters.
So far as children is concerned,
handling others' husbands and others' wife is not our forte.
Absolutely not.
Not even our own wives, so it's very difficult.
There is some doubt.
So you have to. If you want to go back, go back.
I am willing to go back.
Difficulty
is there.
Go back. The litigation will be over in a day.
So far as children is concerned, that 1 year 9 months, 21 months old children. He is depriving of taking care of the mother.
Revision. The revisional court will be a better court for that. Go to the revisional court. We'll hold that the appeal is not maintainable. Go to Justice Bhattacharya and.
In that case, what I am submitting, can you give me the certificate copy?
Oh yes, absolutely. A preliminary objection. I'm not the other preliminary objection. Very well, we're also recording. 2 preliminary objections are taken to the maintainability of the appeal by learned counsel for the respondent. First, it is argued that the impugned order, coming within the contemplation of section 12 of the Guardians and Wards Act, comma, 1890, comma, is not applicable under section 47 of the said act. Full stop. Secondly, comma, it is contended that there have been subsequent extensions of the interim order which has been challenged herein. Full stop. Since the extension orders have not been assailed, comma, the present appeal, comma, even if allowed, comma, would be toothless. Full stop. Learned counsel for the respondent cites a coordinate bench judgment of this court in the matter of FMAT, in the matter of Siddharth Gupta versus Somdeo Gupta and others, within bracket FMAT 1102 of 2017, in support of such contention. Full stop. Next para. Learned counsel for the petitioner submits that the present order is in the impugned order is in the nature of one under section 7 of the Guardians and Wards Act 1890 and not an interlocutory order under section 12. Full stop. Next para. However, comma, upon a perusal of the relevant provisions of the Guardians and Wards Act, comma, we are of the opinion that the impugned order pertains to the, within double inverted, protection of the person, double inverted clause, of the minor, and, comma, as such, comma, comes within the purview of section 12 of the said act, which of hence, comma, no appeal lies against such order. Full stop. Next para. In view of the above observation, comma, we are not entering into the merits of the second objection as to maintainability. Full stop. Next para. Accordingly, FMAT 39 of 2025 and Can 1 of 2025 are dismissed as not maintainable, with liberty to the appellant to prefer an appropriate challenge before the appropriate forum. Full stop. Next para. Leave is granted to the learned advocate on record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records. Affidavit of service filed to be kept on record. প্রথমেই করি বইটা
for the appellant.
Eviction.
Eviction. Today fixed for hearing of the stay pitch.
Eviction of a what? Trespasser or licensee?
Or on the ground of 2G.
2G.
2G of the
What is your prima facie case?
My prima facie case is there, my lord, that I am the co-tenant, my lord.
Have you granted any ad interim order?
Ad interim
There
order.
are directed us to file our affidavits. We have filed our affidavits.
Occupation
Affidavit are
In
extended.
respect of the identical property, in respect of the same property, my lord, I have let out a portion of it for tenancy, and I am getting a sum of rupees 35,000 as well as 55,000. And whereas they are paying only 200 rupees to the rent controller.
35,000
and 55,000.
That is
two separate. I entered into two separate agreements in respect of the same property of two different rooms.
The sizes are the same.
Almost identical.
No
Here,
commission has been done.
The property is situated at Girish Park on Central Avenue, in the heart of the city, and they are enjoying it without
on Girish Park or inside.
On the Central Avenue near Girish Park area.
Yes.
No area has been mentioned in the plan, my lord. And my lord,
what area? The police station will reveal.
No, my lord. The measurement of the
measurement
of the tenancy, my lord, not mentioned in the plan, my lord. And
Well,
what
we
happened,
have
my lord?
stated so in our affidavit.
We are in there, my lord, since 50 years, my lord, as a residential purpose, my lord. And they have let out for the
so you have got adverse version then?
No, my lord. And they have let out for the purpose of commercial purpose, my lord.
Precisely, that is the test. What is the maximum amount they can fetch from that area if it is let out today? It's a commercial area. Central Avenue, Girish Park is a commercial area.
And we are also paying the rent before the rent control. Since
it's your choice, but you have to pay occupation charges. 55 and 35. Somewhere in between.
It is a residential portion, my lord. Therefore, commercial purpose. Kindly consider, my lord.
We can take the lesser sum of 35,000 then, subject to hearing Mr. Dev. Your user is not important. That is the difficulty. As per Attaram and whatever follows.
Lordship knows very well.
Whatever they can do with the problem, because they are enjoying an eviction decree. The principle is that we are holding the hands of the executing court, that they cannot execute till the appeal is heard out. For that, they have to be compensated. What is the rate of compensation? Whatever they could fetch at the current market rate.
My lord, they are not my defaulter.
The test.
That is not for default ground, my lord. We are not defaulter, my lord.
It is under Order 41 Rule 5, not question, no question of default. It's a condition of the stay.
My lord, I
Not
appreciate.
even mean profits, strictly
I
speaking.
appreciate, my lord.
So we'll take
But-
the lesser amount 35 and 40, 55, where have you stated?
If your lordship kindly comes to page 7, 9, and 11 of my affidavit in opposition, as well as at page 21, 23, and 24, I've annexed both the agreements.
We'll shut our eyes to the 55. We'll see the 35, and where have you stated the area?
Yes, lordship kindly comes to para 3. Para 12 at page 3, paragraph 12.
For not this portion, my lord, that portion which they have let out.
550 square feet.
Back portion fetches 35,000. This is the front portion. They should fetch more. What are you saying?
We are in the last portion, my lord. Then the dead end, there is
Last from the end.
we are in the back portion, my lord. We are not in front portion, my lord. And their case is there is a dead end, my lord. And we are residing that.
Let us see. Let us see the affidavits. Let them place first, because we are on occupation charges. Take your seat. We'll grant. We'll extend the stay, but we'll have to see. Yes, Mr.
Lordship kindly comes to the plaint. I will show to your lordship the schedule.
Where is that? Where do you find it?
Kindly comes to page
of
page 15 of the application for stay.
Yes.
All that 2 rooms with common user of bath and privy situated on the ground floor, premises number 62, Vivekananda Road, Police Station, Hirish Park, Kolkata, 7,06,000.
So one on the north, there is a shop room. 2 passages are there on the 2 sides.
And on the west by premises number 60.
It does not have an opening to the road, main road.
The premises that is 62 itself is situated on the main road.
But not there 2 rooms. Not there 2 rooms. On the north, there is a shop room.
Yes.
South passage, east passage, left, different premises. So they are behind that shop room probably. So can it be equivalent to a shop room? Let us see your 35,001.
Lordship kindly comes to page 7.
Yes.
But this is dated 1st August 2023.
Right.
Now, Lordship kindly comes to page 9. The address in respect of this agreement, that is 60 Vivekananda Road, Police Station.
Is the boundary given there? Let us come to the boundary.
Yes.
Page 17 is the boundary, or?
Lordship kindly comes to page 70.
This has the main road on the north.
Yes.
It is a better situated. He rightly said that.
This is 570 square feet on the ground floor of premises number 62. And I am getting a rent of rupees.
These are front rooms, 35,000.
35.
And the other one is 55,000, similarly located.
Kindly come to page 21, the agreement starts. This agreement is of 1st May 2024. And if your lordship kindly sees the schedule, which is at page 31.
And this also faces the Vivekananda Road.
Yes.
So it's a better location. This property, his rooms, those are not commercially exploitable as such, Mr. De.
But only one thing,
if they're on the rear portion,
they have not disputed the amount that I am demanding. What they have stated in their affidavit in reply is that occupational charge will not be there.
Not be?
Quantum of occupational charge, they are challenging it, but they have not denied that they are not liable to pay accommodation charge at the market rate.
No, that is the law. How can they deny? What is the occupation of this person? No. You have had the affidavit affirmed through your wife. What do you do? What does Satya Shah do?
Sir is doing business.
What sort of business?
Business.
We hope not from that property.
Not from that property.
Reena Jaiswal, who is that?
Jaiswal also one of the.
No, Reena Jaiswal is the respondent.
Is the respondent.
So let us see whether Satya Shah affirmed an affidavit.
My lord, builder shop is one of the
No, you are in business, so
appellant, my lord.
35,000 means that they for a room having an opening on the main road. It has to be less for them.
My lord, I have put on a reference point before your lordship. I leave it to your lordship as to the amount. And these are the two, one of, I can say, my lord, safely, these are the latest agreements.
25. কিন্তু পেছনের ঘরগুলো কমার্শিয়ালি এক্সপ্লয়েটেবল না, এটা দিচ্ছে 35, রেন্টাল ও তো 200 টাকা দিচ্ছে। রেসিডেন্সিয়াল কোনো ও দুটোই দিয়েছে ওই সেম প্রপার্টিতে, কিন্তু ফ্রন্ট রুম যেটা ওপেনিং অন দ্য মেন, সেটা কমার্শিয়াল এক্সপ্লয়েটেবল। তো ওই
Kindly consider, my lord, that
after considering, there's a discussion for that
for
purpose only.
residential
That
purpose,
this
my
was the consideration.
I appreciate, my lord.
So we cannot go below 20,000. As a division bench, we cannot go below 20,000.
The date of decree is 20/12/2023, and my lord, I humbly submit I am entitled from the date of decree.
Date of decree 2012, 2023, 2012, 2023, 1 year. The area rents will be lesser. The area at a lesser rate, 10,000 maybe. The stay application has been filed in connection with an appeal against an eviction decree, whereby the learned trial judge granted eviction against the appellants on the premise that the appellants come within the purview of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997 and as such has been rendered trespassers in respect of the property, suit property. Full stop, next para. Learned counsel appearing for the appellant submits that the property, the suit premises is comprised of how many rooms? 2.
2 rooms, my lord.
2 rooms at the rear portion of the building housing the same, and as such cannot be commercially exploited. So furthermore, it is argued that the appellants are using the said property for residential purpose. Full stop, next para. At present, the appellants are depositing rent occupation charges at the rate of rupees 200 with the rent controller.
234.
How much?
234.
234 rupees 234 per month with the rent controller, and as such it is submitted that the occupation charges for grant of stay may be commensurate with such payments. Full stop, next para. Learned counsel appearing for the plaintiff's respondents opposes such prayer and places reliance on the affidavit in opposition filed in connection with the stay application. Full stop, in the said affidavit, 2 agreements have been annexed indicating that that other rooms in the same building have been let out to strangers to the litigation at much higher rates. Full stop. For one of the said for one of the said portions, the respondents are getting rent to the tune of rupees 35,000 per month, and for the other, rupees 55,000 per month. Full stop. It is further argued that the location of the premises is such that it is commercially exploitable. Full stop. Hence, it is contended that occupation charges should be paid commensurate with the market rent which can be fetched by the property at the present juncture. Full stop. Upon hearing learned counsel for the parties, we find that although the location where the suit premises are situated is a highly commercial area, still, fact remains that the 2 rooms comprised of the suit premises is situated at the rear portion of the building, having no direct outlet or frontage to the main road. Full stop. Next para, that apart, comma, the premises are being used for residential purpose at present, and the suit premises cannot be placed on an equal pedestal with the other rooms regarding which agreements have been annexed to the affidavit in opposition, comma, both of which have frontage on the main road and are much more commercially viable than the suit premises. Full stop. Next para, hence, comma, keeping on balance the interests of both parties, comma, we are of the opinion that occupation charges at the rate of rupees 20,000 per month would be commensurate with the location of the suit property. Full stop. However, comma, also considering that the defendants appellants have till date been paying only rupees 234 per month, comma, the area occupation charges ought to be fixed at a lesser rate, that is at the rate of rupees 10,000 per month. Full stop. Next para. Accordingly, Can 2 of 2024 is disposed of on contest, comma, thereby granting stay of all further proceedings. There is an execution case. We are granting stay of operation of the impugned degree and the connected execution case till disposal of the appeal, subject to the appellants paying to the plaintiff stroke respondents occupation charges at the rate of rupees 20,000 per month. Full stop. The current occupation charges, comma, starting for the month of March 2025, comma, shall be paid by the 10th day of each current month. Full stop. The first of which shall be by March 10, 2025, and thereafter by the 10th of each succeeding month. Full stop. Next para. Insofar as the arrear occupation charges from the date of the impugned decree till the month of February 2025 is concerned, comma, the same shall be paid at the rate of rupees 10,000 per month by 4 equal monthly installments, comma, payable. Now, the first of which installments shall be paid by March 10, 2025, and thereafter by the 10th of each succeeding month. Full stop. Next para. The payment shall be made directly to the respondent would you like to give a bank account by way of online transfer at the bank account, comma, the particulars of which shall be furnished in writing by the learned advocate for the respondent to the learned advocate for the appellants by February 21, 2025. Full stop. Next para. Such deposits shall be subject to the outcome of the appeal. Full stop. Next para. It is made clear, comma, however, comma, that in default of any of such payments, comma, either current or arrears, comma, the stay order shall stand automatically vacated without further reference to the court. Paper books, yes. In view of appearance of the respondent to her learned advocate, notice of service of notice of the appeal on the respondent is dispensed with. The trial court records shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready. Ready for hearing.
But I fear for the yes. Lord, coming up against an eviction decree. Lord,
suppose for the other side.
Yes. Lord, when I moved this appeal, I had said, Lord, I need 6 months time to vacate. And Lord,
yes.
That on that score, Lord, Lordship had given us time to work out, Lord, the other terms and conditions.
Occupation charges and all.
Everything has been worked out. We are giving up mean profits. I would have been happier if they had vacated a little earlier, but I should not complain. Mr. Kaur has been very cooperative. Well, it's subject to your Lord's pleasure. We've just written out, at the suggestion of the parties, a format if
Absolutely.
might just consider it.
The appeal and the suit is pending because of the determination of mean profit.
Mean profit. So all go.
All both the matters.
Everything now, my lord will consider.
But this undertaking, I am taking a little time to file because, Lord, my client is in Mount Abu, the defendant. She has, Lord, renounced life and she leaves a philanthropic, Lord, in an organization. So, Lord, I am taking this.
How soon can you file that?
By
It's written
7th
there.
March. By 7th March. Your Lordships will find
That's
that.
also there in this.
Yes, it's there in clause A.
It is there. That will tell
7 months last.
page.
No, B says the appellant has furnished a statement showing particulars.
I will furnish, Lord, that
He
may
will
be.
give it to me.
I'll-
That much
I have
faith
got the
have in
file.
Mr.
I have got the file.
Furnish means furnish to you.
Yes,
Not
because
to
we'll have to
the
recover
court.
that one.
For the purpose of recovery of that.
Achha.
Because the money has been deposited, but they wanted the challans and all that.
So we can just make these paragraph 3 clauses a part of our decree,
Yes.
because we'll dispose of the appeal itself.
Yes.
Yes.
We will make this a part of our decree.
Appeal and the suit both, Lord.
Appeal and the suit, yes, obviously. Suit, we cannot do it from here. We can record your
Yes.
because we are not sitting in appeal over
No.
the
Clause also, because in case there is a default in.
default clause is not there.
Yes, it is.
Yes,
Eight.
everything
Then
goes
we will
from A to J. Everything,
execute.
or
H is there.
we can make it a part of the. Have you got a soft copy of this? Supply a soft copy. We'll make it a part of the order. We'll say that we keep this on record, and the appeal is being disposed of in
Very well.
in
Very
terms
well.
of this.
Pen drive aske diye diye to bhai. Acha.
We want only A to J will do.
Yes. A to J will do.
A to J will do.
And Lord, it is mentioned here that the suit itself will also be disposed of.
So should we record that also? Then we'll record that.
Your Lordships, Lord,
Very.
The J includes that.
Very. Learned senior counsel appearing for the parties submit that good sense has prevailed and the parties have arrived at a settlement between themselves. First up, the broad contours of the settlement are that the appellant shall be delivering vacant and peaceful possession of the suit property in favor of the respondent plaintiff before June 30, 2025 and file an undertaking formally to that effect by March 7, 2025. Pushed up. Next para. The payment of occupation charges at the rate of rupees 20,000 and the modalities thereof, as well as the other details of the settlement are recorded in clauses A to J of paragraph number 3 of a written suggestion of parties handed over, filed in court today. First up, such written suggestion of parties be kept on record. First up, accordingly, FA 64 of 2025, along with IA number. IA is also, yes, IA number CAN 1 of 2024, as well as
the ejectment
suit number 9 of 2018 pending in the trial court are disposed of in terms of the settlement between the parties as recorded in clauses A to J of paragraph number 3 of the suggestion of parties. Pushed up, such clauses be deemed to be a part of the present decree and are set out as follows. Colon দিয়ে A থেকে যেটা করতে হবে উনি যদি সফট কপি দিতে পারেন
I will provide that, Lord, by lunchtime we will provide that.
তাহলে সফট কপি থেকে ওটা করুন।
In a pen drive.
Push up next para, there will be no order as to costs. No further order is there.
Much obliged.
Thank you very much, both of you.
We are grateful to your lordship.
Thank you. একদম clear। এটা 20,000।
Well, my lord, I appear for the appellant.
Yes,
For the respondent.
respond, yes.
File an application for restoration and delay is 2,506 days.
Only 2,000.
That has been allowed.
Why?
Has been allowed. Yes. Allowed. Allowed on 16th of January 2025.
Copy service করা হয়েছিল তখন।
Despite service none appeared for the respondent. Copy had been served on your client. Affidavit is on record.
Lord, on the earlier occasion, your lordship was pleased to call for a report from the stamp reporter.
This change of nomenclature. So now it has been done, FAT. So do you have any other application?
No. Other application for expeditious disposal.
What is it? But the decree was passed on 16/12/2016.
Yes.
They preferred it 2017. Now there's a dismiss for default on 18 January 2018.
We have already allowed the restoration. We cannot do it.
By this time, what happened? The husband married second time in the year 2018, and a child was born out of that wedlock, my lord. This is the situation.
They're not asking for an injunction. This is against the matrimony, divorce decree.
Yes, this is divorce.
But they're not asking for, sorry, for an injunction. They're
By this
wanting
time,
it.
husband married second time.
Appeal does
Because
not
there's no
automatically
appeal
go.
at all.
Appeal does not automatically go.
But first matrimonial suit was filed by the husband on the ground of cruelty on 13th of May 2015. Subsequently, wife filed an application under section 24 for transfer of suit from Barakpur to Baharampur. That was allowed. During subsistence of that suit, the husband filed another suit on the ground of nullity of marriage.
Anyway, when we hear the appeal, we'll do that. The present application is for expeditious hearing of the appeal. Full stop. It may be noted that as per our previous direction, the appeal has been reclassified as a regular first appeal and has been allotted FAT number 67 of 2025. Full stop. Next para. In view of appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court records be called for by special messenger at the cost of the appellant, which shall be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion as and when the same is ready for hearing. Full stop. Can one of 2017 within bracket old number can 5767 of 2017 is disposed of in the light of the above observations without any orders to cause.
Lordship, item number 13, I am appearing on behalf of the appellant's lordship,
Are
led
there
by my
direction?
senior advocate Molay Bhattacharya.
I am submitting my affidavit in opposition.
In opposition.
There was a direction, my lord.
Lordship, there was a direction to file our reply also.
Yes.
Lordship, in their, as per my instruction from my senior lordship, in their opposition, they have bring some points describing the rental value of the property, lordship, but I am my concern is about 2 rooms that is on the first floor of the premises 7A.
You are given liberty to file an affidavit in reply.
Yes, exactly, lordship.
What is that reply?
Lordship, I will require some time because lordship, they have mentioned the details, the value of the property as a commercial property, and they have mentioned the value of the entire property, lordship. But my concern
When
is
was the
about
copy served on you?
lordship on 29th of January, lordship.
Today we are on.
18th, lordship.
So almost a month back. You have got sufficient time. Then we'll vacate this stay.
Lordship.
We'll vacate this stay or make it limited. We
Lordship.
had granted it till disposal of the application, but because of your delay in the matter, you are unnecessarily delaying the matter. You have taken 1 month, you could not find out sufficient documents.
Lordship,
No, then we'll vacate this stay. You cannot enjoy a stay, unlimited stay by dragging the matter. No, sorry.
That
We'll modify your order. We'll
Your
take it.
Lordship, just grant me a 7 days time, Lordship. We will file that same.
But this is the last chance. Learned counsel for the appellants seeks an extension of the time for filing reply. Of the affidavit in opposition filed by the respondents today be kept on record. Of next para, we find from the records that the leave for filing affidavit in reply was granted as long back as on January 14, 2025, and the opposition was served on the learned advocate for the appellants quite some time back. Hence, comma, although we do not find any justification for the prolonged period taken by the appellants to file their reply, comma, as a last chance to the appellants to file such reply, comma, the time for filing of the same is extended till February 25, 2025. The matter shall next be listed on March 4, 2025 under the same heading. So you'll get some time to go through the reply also. Thank you.
See, in this matter, I am for the appellant petitioner.
Yes.
Your Lordship, here to matter on 14th January. 14th January, when I submitted.
এই মাইকটা একটু দেখিয়ে নেবেন অনিন্দিতা আপনি আজকে রিসেসে please use the other microphone. We have become habituated to microphones and that's why it's difficult for us. Previously, I mean, everybody heard without microphones, but now we have habituated ourselves. Be a bit louder and use one of the microphones. Yes.
When I submitted affidavit of service,
Yes.
on the envelope it was written left.
Left.
The respondent left. For this reason, your Lordship directed the appellant for necessary correction in the cost.
Right.
But I ascertained from the appellant petitioner that the appellant petitioner and the proposed substitute respondents both are still living in the same house, the address stated in the cost title. Lordship, in this situation, I submit one thing, kindly direct me to serve the copies by special messenger. Otherwise,
Special messenger in his personal
the
service.
Honorable High Court.
High Court special messenger cannot. There is no such
Otherwise,
person.
it will be act of the postman that there is the left.
Then rule has to be issued.
Service cannot be effected.
Then a rule has to be issued. Rule will take much time.
Lordship,
What is the appeal against?
by any other, yes, my lord,
Appeal has been filed against what judgment?
or second court of the city civil court.
No. What was the suit for? You are enjoying any interim order?
No, my lord.
Your appeal will be delayed much. Try
No,
to serve again.
Appeal was filed in time, but during pendency of the appeal,
No, then
in this
serve
court-
again. Serve again at the same address. If you issue a rule, it will take much time.
by post, my lord.
By post, yes.
Yes,
You can also effect personal service. Unless there will be a fight between yourselves if you try to personal serve.
then, my lord,
Serve again, take a chance. Somebody will accept and then.
kindly direct me.
By our order dated January 14, 2025, we had recorded that the appellant is required to ascertain the current address of the respondent, comma, since the envelope sent on the earlier occasion returned with the endorsement left, double inverted. Next para. Upon ascertaining from his client, comma, learned counsel for the appellant submits, comma, however, comma, that the appellant and the respondent are still residing at the same premises, and as such, the respondent is deliberately avoiding service. Next para. Hence, comma, the appellant is directed to serve a copy of the application afresh on the respondent at the latter apostrophe address as given in the cost title of the memorandum afresh, and file a fresh affidavit of service to that effect on the returnable date. The application shall be listed in the monthly list of March 2025.
Lordship, propose substituted respondents. Service will
Acha,
be-
thank you. On the respondent na kore propose substituted respondent. Thank you. Yes.
I am for the
You're for the respondent? Yes, Mr.
Lordship,
Chok.
I am for the on behalf of the respondents. Your Lordship, I pray
I'm
for a
filing
short
the-
Passover as my senior Mr. Krishnadas Fuda is appearing in another court. Your Lordship,
You are there. You will move there. You will contest the matter.
I only have this instruction. Your Lordship,
You don't have the brief.
I have the brief, but
Then you will oppose.
Your
Yes.
Lordship, I am not attached. I was not attached with this brief, so I kindly request Your Lordship to
Read the brief. We'll give you 10 minutes.
Your Lordship kindly takes up the matter at 2 p.m.
We'll give you 10 minutes. Mr. Chakraborty, please wait for 10 minutes. We'll take up. Passover for 10 minutes. Or we'll take it immediately after we come back after that 12 to 12 minutes. You can go to some other court, Mr. Chakraborty. We'll take it up at 12:05. And you will have to start the matter. You go through a brief, even if Mr. Poddar comes. That is the rider. Passover থাক 12 এর পর এটা প্রথম ডাকবেন. What is your name, please? Mr. Maiti, you will have to start the matter. Tell Mr. Poddar you have told that. Even if he is there. Yes.
Regarding item 16, Mr. Bolailal sir appearing for the appellant. He has
Yes.
paid for an
Yes, Mr. Bills. How prayed in the morning?
For 2 p.m.
For 2 p.m. ঠিক আছে কোনো অর্ডার রেকর্ড করছেন এটা 2 p.m. রাখুন. This will be taken up at 2 p.m. বলাইলাল স্যার সকালে মেনশন করেছেন.
But I am appealing for the appellant.
Yes.
This appeal arising out of a grant of succession certificate. Stepson applied for succession without making me as a party. I am the wife of the erstwhile husband, second wife. Admittedly, he has challenged my marriage by filing suit. Suit is pending and suit for declaration that the marriage is nullity. In spite of that, we file an application before the executive succession court, order 1 rule 10. That was rejected and a succession was granted. On the ground that he was married, virtually that suit has been degreed.
By the same order, order 1 rule 10 was rejected and the succession has been
granted.
And you are challenging both, obviously. So this is
the
appealing
first
for
time is appealing.
First time. So what have you asked for? What is the
But I am asking for the money lying with the LIC not to be dispersed in the meantime. 1,80,000. Otherwise, all other money has been settled by the appropriate authorities. The only thing is that leave to appeal is there also.
Leave to appeal will grant. Just let us see the prayer portion of this stay once, because you have to grant in terms of that. You ask for stay. You ask for stay of the stay.
Adding to stay page 50.
We'll grant stay in the interregnum. The present appellant is the present appellant claims to be the second wife of the deceased Sunil Kumar Haldar, in respect of the estate of whom a succession certificate has been granted by the impugned judgment and deemed decree. Full of next para. It is contended by learned counsel for the appellant that the respondent, without impeding the appellant, who is the second wife of late Sunil Kumar Haldar, obtained such succession certificate, which upon coming to know of the pendency of the succession proceeding, the appellant filed an application for adding herself as a party to the said proceeding under Order 1, Rule 10 of the Code of Civil Procedure. However, the said application was dismissed by the learned trial judge as well as succession granted in favor of the respondent. Next para, learned counsel further argues that at present, a suit is pending at the behest of the respondent seeking a declaration that the marriage between the appellant and her deceased husband, late Sunil Kumar Haldar, was a nullity. It is argued that during pendency of the said suit, it could not be conclusively decided that the present appellant is not the wife of the said deceased, and as such, the very premise of the grant of succession certificate in the absence of the appellant and rejection of the appellant's application for addition of party is bad in law. Next para. Since the appellant was not impleaded in the court below, but obviously has a direct interest in the outcome of the succession certificate proceeding, comma, as is evident from the above discussions, comma, can 1 of 2025 is allowed, comma, thereby granting leave to the appellant to prefer the appeal against the said judgment. Push up next para. Can 2 of 2025 has been filed by the appellant for stay of operation of the impugned judgment and degree, whereby succession certificate has been granted in respect of the estate of the deceased Sunil Kumar Haldar, comma, the alleged husband of the appellant. Push up next para. Since the appellant has made out a prima facie case for the appeal being heard on appeal and the application being heard on merits, comma, we grant stay of operation of the impugned judgment and order within bracket deemed decree dated December 23, 2024, passed by the learned civil judge within bracket senior division, comma, first court within bracket district delegate bracket closed at Asansol district Paschim Bardhaman in succession case number 50 of 2021 till disposal of can 2 of 2025. Pushed up. The appellant stroke petitioner shall serve a copy of the application on the respondent stroke opposite party, indicating that the application shall next be listed on March 10, 2025 under the heading application, when an affidavit of service to that effect shall be filed by the appellant.
Lord, I am
Yes,
the
Mr. Chandra.
petitioner, my Lord. Why petitioner before your lordship in connection of a matrimonial suit?
Divorce granted.
My Lord, divorce granted. Good filed by the husband.
Obviously, yes.
My Lord, this application filed for stay of the impugned order, impugned judgment and degree, my Lord.
It's a judgment in rem, it has its connotations. Will injunct the respondent.
Yes, alternatively.
Oh, you have read that alternatively.
No, in there, but such other order or orders, your lordship very much.
So we'll mold the relief. We'll grant.
Yes.
But we don't know whether he has married in the meantime.
Judgment was passed in the month of December, I think. But nowadays, your lordship very much are behind the judgment. All persons are doing anything.
Let us pass an order, then they'll come and seek vacation.
But one thing more, my Lord, the cost title was given in the plain as well as the degree. The judge, the husband is not living there. My client said that the address where he is living. So alternatively, your lordship kindly direct me.
Serve at both addresses.
Yes, madam. Grateful to your lordship.
But only one has been residing at railway quarter. Only one address has been given.
Otherwise, the SR will give report because
no, this is the address as given in the code below.
Code below as well as degree.
Yes. But what is the new address? You have to. Will give you leave to rectify the cost title by introducing the current address as well.
But by way of again amendment or
we'll grant to leave right
yes,
now.
Yes,
you will just amend the cost title of
here and now.
Here and now.
Yes.
Application as well as the memorandum. Just introduce also at or something like that. Currently at you know what to do.
Yes. Yes.
The present appeal has been preferred against a decree of divorce obtained by the respondent husband. First up, learned counsel for the appellant argues submits that the address of the respondent given in the code below is an incorrect address and the husband resides elsewhere. First up, next para. Accordingly, comma, leave is granted to the learned advocate for the appellant to amend the cost title of the memorandum as well as the application by incorporating the current address of the husband, respondent husband as well in the cost title. First up, next para. The appellant shall serve copies of the application at both the addresses of the respondent, indicating that the application shall be listed for hearing on March 10, 2025 under the heading applications. First up, an affidavit of service to that effect shall be filed on the returnable date. First up, next para. Since the impugned judgment is in the nature of a judgment in rem, comma, we choose not to grant a stay of the same at this juncture. First up, however, comma, since a prima facie case has been made out, comma, we mold the relief and restrain the respondent by an order of injunction from contracting any remarriage during pendency of the application. Full stop. This much.
Yes. I have also filed the Talawana because we came to learn from Bharchaji that when you file memo, Talawana. So your lordship kindly
It
direct.
is a forgotten chapter now. Now even lodging of final order, then also it's not deposited. Some deposit in time, not all. Yes. Yes, Mr. Jha.
I beg to appear for the appellants in the matter. On the last occasion, your lordship had directed me to file to take out supplementary affidavit. I'm placing that on record, my lord.
What is the matter about?
Lord, this is regarding refusal of an injunction order, my lord. Where the partition suit was there.
Appeal must have been admitted. Previous, yes.
And a substitution application has also been taken out because respondent number 3 had died and we were intimated on the last day about the date of death. So we have even taken out an application for substitution, my lord.
So substitution has been taken up first.
My lord. The reply towards it.
Substitution is which one? Can
2.
2. Yes.
Only one thing, my lord, in the
Yes.
substitution application, my lord, there is lack of pleading. The issue is that the right to sue survives. These are not, my lord, stated in the substitution.
Then it was
And the parties
major and sui juris and all.
These are the facts has to be incorporated in the substitution.
These have to be
technical entirely.
Not technical. These have to be there. Otherwise, we cannot allow it. It is not formed.
I understand what is falling from your lordship. I should have gone through the
Substitution application. This is necessary. Major sui juris has to be there.
That is not there. I have seen, my lord.
But what is the supplemented? The supplementary affidavit is in connection with the other application.
Other application.
Do you deny that they are major and sui juris?
No, my lord,
Then will not be
that-
technical.
I'm
Otherwise, another 2 months will go.
Yes.
Now that I have to withdraw this and file another application.
No, you can file a supplementary affidavit to that also.
Let that come on record because if I have to go to a higher forum, then these points will be taken there, my lord.
Yes. Yes.
Let me come up with another affidavit,
Because
my
it
lord.
is my duty to point out.
No, rightly so.
No, rightly
Mr. Prasad,
said,
absolutely.
rightly
You are 100% right. This has to be there. This is a mandate of law.
My lord.
And another prayer, my lord, the appeal has been preferred against the my lord final disposal of the
Injunction
application. My lord, we want to be my humble prayer before your lordship and submission also that this injunction application has been rightly decided. And my lord, kindly after the my lord, this substitution, if after this completion of this substitution application, let it be taken up because there is a
Immediately after deciding the substitution, we'll take up the
Yes,
injunction.
yes.
We always do that. Whatever applications are pending, we take up one
Yes,
after.
yes.
You have filed a composite affidavit in opposition.
Yes, ma'am.
And I have filed my reply.
You have filed your reply, right? The composite affidavit in opposition to the injunction application, comma, the supplementary affidavit to the injunction application, as well as the reply filed today be kept on record. Full stop, next para. However, comma, before taking up the injunction application, comma, the application for substitution is taken up for hearing. Otherwise, substitution is in time.
My lord.
Full stop, next para. Learned counsel for the respondent rightly points out. You are for which respondent?
My lord, we are 1 to 4.
1 to 4, exactly.
Respondent numbers 1 to 4. Learned counsel for the respondent numbers 1 to 4 rightly points out that the necessary pleadings are absent in the substitution application as to whether the substitution application is in time and the applicants are major and sui juris. Full stop, next para. Learned counsel for the appellant seeks leave to file a further supplementary affidavit to Can 2 of 2024. Further together. A supplementary affidavit to Can 2 of 2024 incorporating the necessary pleadings. Full stop, accordingly. Let the matter stand adjourned till, we'll give you a week.
My lord.
Let the matter stand adjourned till February 25, 2025, when it will be next listed under the same heading. Full stop, leave is granted to the appellant to file a supplementary affidavit on the returnable date with an advance copy to the learned advocate for the respondent.
My lord. Much obliged, your lordships.
My lord, can it be 26, my lord?
26th. Hell, 25th or 26th.
25th, let it be 25th because 26, Paras my lord is taking up the hearing matter.
First hearing matter, ji.
My lord, 25th, let it be 25th.
That 25th যা আছে তাই থাক। এগুলো একটু সাজিয়ে দিতে হবে, হ্যাঁ? ক্যান ওয়ান আমি করে দিচ্ছি দড়ি ফড়ি বাদ দিয়ে দেবো। আচ্ছা ঠিক আছে আপাতত থাক, এখন টাইম ওয়েস্ট হবে। হ্যাঁ গুছিয়ে দিয়েছি, এখন আপাতত গোছানো আছে, এরকমই রাখলেও হবে।
Obliged, Your Lordship.
Thank you. আপনি মেডিকেল দেখে নিয়েছেন? ভালো করে একসাথে এগিয়ে থাকি।
Item number 20, I am led by Mr. Kushal Chatterjee. His father has just been admitted in the hospital Lordship, today morning.
What happened to his father?
He is suffering for last
pretty
for
long
few
time.
days.
Kushal Chatterjee, Mr.
Yes,
Chatterjee?
Yes.
His father is suffering from pneumonia.
And in the morning, my lord, I have
Has been admitted
told that
to
he has
Fortis.
been-
Definitely. When should I keep it?
Keeps it in the next week, Your Lordship. Adjourn this for this week.
For this week. Very good.
I am supporting him, not.
No, definitely. We are also supporting. On the prayer of the appellant, let the matter stand adjourned till when? February 24th?
Yes, Your Lordship.
February 24th, 2025. Next month.
Thank you.
Item number 21.
Adjournment refuse, move the matter.
What possible?
No Passover. Where is your brief?
Yes.
Without a brief, you don't grant adjournment. Sorry. We don't grant adjournments without briefs. He had hidden the brief. He has to start. Yes, start the matter. What is the matter about? Patient chair.
I'll take the seat.
You remain there. You may be needed. So what about the response? There is no other side. Oh, this is the
Substitution applications are pending.
substitution is pending.
There are 5 substitutions.
So we have to decide those.
We are already done with 2 are left.
So let us hear those first. Yes, you move them. Which applications are pending? Give the numbers.
Can 2 and can 9, Miller.
Give the old
9 and
numbers.
Can 1, can 2,
And can 6.
Give the
Can
old
2 and 6.
Give the old numbers.
Old numbers will also have.
Can 2 and can 6.
Can,
Very good.
can.
One is 1024, another 9202.
আমার briefটা কোথায়?
1024, 1024, 920. Yes, we have got those. So these are in time or beyond? Very well. Can 2 of 2009 within bracket old number can 1024 of 2009 is an application for substitution of the heirs. You have checked up, both are in time.
Well, I checked up, Miller. That's why I'm finding my markings, Miller. All botched up. You guys give me a moment, Miller. Kindly bear with me. Yes, Miller. Now, can can 6 may be taken up first. I'll got the copy. Baki can do that.
আচ্ছা স্যার যেটা বললাম কেটে দিও না
9202.
9202 yes.
So this is for substituting the names of the respondent number 2, Shankar Ganguly. The respondent who passed away on 10th of July 2019. The application was filed on 12th of September 2019. Within time. Substituted as 2A to 2D.
Well, প্রথমে can 6 টা করে দাও। Can 6 of 2019 caption হবে। The present application has been filed for substitution of the heirs and legal representatives of the original respondent number 2, namely Shankar Ganguly, S-A-N-K-A-R, Ganguly, who has passed away during pendency of the appeal.
I'll give the date, Miller.
No, need not. Push up next para. Since the application is in form and otherwise is in time, can 6 of 2019 within bracket old number can 9202 of 2019 is allowed, comma, thereby directing the substitution of the heirs and legal representatives of the deceased respondent number 2 as respondents 2 series in the appeal in place and state of the said deceased. Full stop. The necessary corrections shall be carried out by the learned advocate on record for the appellant during the course of the day in the memorandum of appeal. Next para. What about the other one?
The other one is Lord Can 2 of 2009. That is old Can is 1024 of 2009.
Yes. What is this
So
for?
this is the appellant number 1 has passed away, Lord.
Is the heirs are on record or?
Yes, no, Lord, so it needs to be substituted.
No, you have stated that. Two is already his son.
Names of the appellant number 1, Sanatan Ganguly, who is the father of the appellant number 2, is required to be deleted from the cause title.
Yes.
Appellant number 2 has been implicated in the second appeal. The capacity of pardon holder. Same the appellant number 2 needs to be recorded. Some substituting names of the appellant number 1 to 7.
Oh, he was implicated as a power of attorney holder, but
Here against the power of attorney holder, there are others.
so there are other heirs also.
Yes, Lord.
Yes, Nirmala and others.
Nirmala, Sopon Ganguly, Nilima Roy.
But what about their details? You have not given their addresses.
The paragraph number. Well, same address is the same.
You have not stated that. You have given in the cause title.
There was a
So in the cause title, you have yes. Very well. Next, can tutor. The present application is for substitution of the heirs and legal representatives of appellant number 1, Sri Sanatan Ganguly, on his demise during pendency of the appeal. Full stop. Next para, since the application is in form and in time, comma, can 2 of 2009 within bracket old number can 1024 of 2009 is allowed, comma, thereby directing the heirs and legal representatives of the deceased appellant number 1 being the present appellant number 2 as well as the pro forma respondents as mentioned in the cause title of the present application in place and state of the said deceased. Na, pro forma respondent corona. And in paragraph number 8 of the application in place and state of the said deceased. Full stop. It is recorded, comma, on the submission of learned counsel for the appellant that the said legal heirs, as mentioned in paragraph number 8 of the application, reside at the same address as appellant number 1. First of the necessary corrections in that regard shall also be carried out by the learned advocate for the appellant during the course of the day.
We'll file a fresh, we'll do a lot of corrections.
In view of the number of corrections, comma, we direct a fresh memorandum of appeal to be filed by the appellant incorporating the names of the substituted parties within a week from date, within a fortnight from date. Full stop. The matter shall next be listed on March 5, 2025 under the same heading.
The can 1 is only pending. That is this application for stay. It has to be heard out with the along with.
That has to be after order for under the same heading as we can do. Returnable date. এটা উঠে এসে আবার যেটা পাস ওভার করেছে ওই বার No, you need not be sorry, but he has to start. Let him start.
My lord,
When your turn comes.
my lord,
Yes, Mr. Chakraborty, what is that?
my lord, I am in possession of
application, my lord.
I am in possession of only one room, my lord, with a common bath and PV. Last paid rate of rent was 150 per month. It is situated.
Eviction granted on what ground, Mr.
My lord,
Chakraborty?
eviction on the section 2G, my lord.
Oh, 2G.
2G, my lord, I have established prima facie case, my lord.
One room with PV.
One room.
What is the locality?
Locality within Posta area, my lord, Nolini Set Road.
Popularly known as Bodabaja Sonapurti.
No, will come.
It is residential purpose is used for residence by only one room.
What have they said in their opposition?
They said that including courtyard passage, they are saying that it is 300 square feet. Who is not correct, my lord.
Let us see the decretal property that
degree. Your lordship will find it from the degree.
Yes.
Description of the property is there, my lord. One room.
One room on the ground floor at
Yes.
premises number such.
This is
One side wall, common passage, etc. So wall, common passage. It does not open up on the main road.
no.
Very well. What is the size of the room? Have you stated?
I have stated in the reply 100 square feet, and according to my learned friend, 300 square feet.
Perfect.
My lord, one room 300 square feet is very rare, my lord.
It's a residential property.
Residential property.
Used as a residential.
Residence.
Where have this? Let us hear them first, Mr. Chakraborty, because it's then he will come in. Yes. You have to start, then he takes over.
Your lordship, they are a trespasser. They are a rank trespasser, and they never.
That will be decided in the merits of the appeal.
Okay.
But what about the occupation charges now? What have you stated in your opposition?
Your lordship, they are required to pay 100 rupees per day for the mean charges. But the area is Bodabaja Shunapatti, and the present value of that area is 1,000 rupees per day.
Have you annexed anything to substantiate that? Mr. Pudar, you can come up now. Yes. Thank you. Yes.
Before my lord,
But you have to leave more to him in future.
put this about valuation, market value. But perhaps your lordships remember at the time of placing stay application,
Yes.
they, my lord, without asserting their status, any document about they are staying in the shoot premises, because it is our case on the death of the original tenant, my lord, original tenant having no issue. They, my lord, came all of a sudden, my lord, trespassing into the premises. Ashok Shankar claiming that I am the she nurtured me, so I have right to observe search ceremony. He observed search ceremony. These all these things that he admitted that he is not the legal heir, he is not the son, or he is any nephew or nothing. On the other hand, my lord, no papers, voter ID card, my lord, Aadhaar card, or any sorts of school certificate or any trade license, nothing of sorts. He relied in the suit or before your lordship. He, my lord, relied vehemently on the probate proceeding, a will left by the.
Mr. Both these are on the merits of the appeal.
He argued.
No, you show us what have you annexed to substantiate the occupation charge.
Well, occupation charge, my lord, kindly.
You have not annexed any contemporaneous document or any other person's rent receipt showing that it would be higher.
Not receipt. My lord, kindly see page. I annexed, my lord, will for your lordship producer, and my lord, page 9 of my reply opposition. Lord, kindly see, this is the market value of my property which I obtained from the.
No. What is the market rent? Market value. This is for sale of the property.
Yes, market, my lord, annexed page 11, my lord. I annexed, my lord, the area. It is Sonapoti. Some pictures of the, my lord. It is there's Dolly Sarkar Street, my lord. This is, my lord, Bodabaja Sonapoti, my lord.
All right.
If this shoot premises
is ventured commercially, it will fetch not less than 1 lakh rupees per month.
Two things, Mr. Poddar. One is that we see from the boundaries of the in the decretal property that it does not open on the main road.
No, it
It's
is not
bounded.
not main road. I am
So
agreeing.
therefore, it's difficult to use it commercially. Somebody doesn't go to the inside of the premises.
That area, my lord,
Also inside.
the goldsmith can run their manufacturing unit.
Acha, very well.
It is Barabajar, my lord.
One. Secondly, you have stated this courtyard and all, but the
All
decretal.
is under occupation.
No, no.
He is occupying all these things.
Mr. Poddar, let us complete the sentence at least one sentence. After that, you will say again. We will say one sentence. Then you will say one. We will proceed like this. I'll try to make that sentence as long as possible so that I can cover. The decretal property as depicted from the decree is all that one room on the ground floor at premises number such and such, which is butted and bounded as follows. You have filed a suit for eviction of him from this. So we have to go by this. How can you say common passage, courtyard, bath? You have not sought for his eviction from those. Then he will remain in possession. Even if you obtain an order of eviction, then you get eviction only from the room and he remains in the common passage. Should you record that he is also in occupation of those? Then you get eviction only of the room. Even if he loses the appeal, you ask for eviction of one room, Mr. Poddar. Even if you dismiss his appeal right now, he gets the courtyard, the common passage, bath and privy and separate water source then. Then let him remain in possession of those. Your sentence now.
He is exclusively occupation in one room. It is true. That may be 100 or 120. But, my lord, at the same time, it is annexed with the amenities of the tenancy, attached to the tenancy, that courtyard, my lord, water source, he is using, his wife is using for, my lord, washing his utensils.
Water source everybody requires.
Yes, yes. So it is.
Every human being requires a water source.
He is occupying, only he is enjoying ground floor courtyard, passage, and bath privy. It is attached to the tenancy. Though tenancy is for one room, and kitchen space is he is using kitchen space. There is no mention here, but he has to cook, my lord, for themselves, my lord. There is some area he is occupying. Some area he is exploiting.
Everybody has to cook for himself
yes.
or at least buy from some.
So, my lord, area of the
These are basic amenities of life, Mr. Poddar.
Yes. For that reason, my lord, as you losses
1,000 per month per square feet.
If it is in Barabajar.
Then it is 1 lakh for a month, even if it is 100 square feet.
Well, if I
What was the rent being paid by your last tenant?
153 or 150.
151.
No, Mr. Poddar. This is a
and my lord, kindly see
an over optimistic estimate.
And my lord, kindly see that we prayed for, look, in the shoot in 2000 when it is 2014, that 100 per day
Mean profits.
So that was accepted. So
mean profit degree has been granted.
Yes.
Where is that?
Yes. It is ordered that the title should be number 34857/2014 is decreed on contest but without cost. But it is in the decree. The plaintiff do get a decree or declaration that the defendant is a rank trespasser from the on the death of the tenant, namely Sitapati Devi Sonkar Folowali, who died on 29 December 2012 till date. Defendant is directed to vacate suit premises within 30 days from passing of this judgment and hand over the vacant peaceful possession of the suit premises to the present plaintiff. The plaintiff are also entitled to have benefit of main profit 100 rupees per day from 29/12/2022.
100 rupees per day is 3,000 per month.
At the calculation of which I prayed.
So even we cannot exceed your prayer for mean profit. Since you have prayed for mean profits, we have to restrict to that.
14.
You have not amended your plaint till date. You have got that decree. That decree still remains.
Now, my lord. Now
we'll make it 3,000 per month.
My lord, now, my lord, now it is.
Occupation charge cannot exceed your mean profits. You have yourself assisted to 1,000.
Occupational charge now. Occupational charge, my lord, increase, my lord, year after year, my lord. So it is we are on 2025, my lord.
Decrease of when? Decrease of 2024.
2024.
You got the degree of 100 per day.
That is about mean profit.
Yes.
Yes, but the current occupational charges, my lord.
Mean profit and occupation charge, what's the difference? Mean profit, the principle is the same. What you can fetch currently from that premises. That is mean profits.
No, what
You can currently fetch if you let it out to some other person from that premises, that is mean profits. That is the principle behind mean.
For in 2014.
Yes, yes. The present application is for stay of operation of a decree and the connected execution case, whose the decree was passed for eviction of the appellant on the premise that the appellant is a trespasser in respect of the premises within the contemplation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997. Pushed up, the appellant, the learned counsel for the appellant argues that the suit premises is comprised of a 100 square feet room and an attached bath and privy. Pushed up, next para, in view of the locality where it is situated, comma, it is submitted that the occupation charges ought to be assessed at a meager rate. Pushed up, next para, learned counsel appearing for the plaintiff stroke respondents opposes such prayer and places reliance on the averments made in the affidavit in opposition, where it is stated in paragraph 12 that the suit premises is of about 300 square feet, comprised of one room, comma, common passage, comma, courtyard, comma, bath and privy, and separate water source situated at 50, Nolini Set Road, comma, police station Posta, comma, Kolkata 7,07,000, comma, popularly known as Sonapatti Barabazar, a fully commercial area. First up, the plaintiff's respondents have claimed occupation charges at the rate of not less than rupees 1,000 per month per square feet. First up, next para. Upon hearing learned counsel for the parties, comma, we find that although the area in Borabazar is an otherwise commercially viable area, comma, as per the description of the suit premises in the impugned decree, comma, the suit room is surrounded by walls, common passages, and other rooms as well as staircase, comma, thereby indicating that it does not have a frontage on the main road. Push up, hence, comma, the commercial viability aspect has also to be considered in moderation. Push up, next para. Secondly, comma, the suit itself was filed by the plaintiff's respondents on the by describing the property to comprise of one room on the ground floor at premises number 50, Nolin Set Road. Push up, next para. Thus, comma, the description of the property given in the affidavit in opposition is much inflated, comma, being beyond the decretal property itself. Push up, even if it were to be assumed that the suit premises are comprised of not only one room but a common passage, comma, courtyard, comma, bath and privy, comma, since the impugned decree has been obtained in respect of only one room, comma, even if the first appeal is dismissed today, comma, the appellant then, comma, by admission of the respondents, comma, would be entitled to enjoyment of a common passage, courtyard and bath and privy and separate water source, since those are not the subject matter of the decree. Pushed up, hence, comma, we cannot go behind the decree insofar as the description of the suit property is concerned, comma, more so since the plaintiff stroke respondents are bound by the principle of estoppel from resiling from the description of the suit property as given in the plaint as well as the impugned decree. Thus, comma, we find that the suit premises is comprised only of one residential room of about 100 square feet, which is situated in the internal portion of the concerned building. Full stop, next para. That apart, comma, we find that the plaintiffs themselves had prayed for mean profits at the rate of rupees 100 per DIEM, which has also been granted by the impugned decree. Full stop. If calculated on such basis, comma, the monthly occupation charges at the rate of the mean profits would be rupees 3,000 within bracket 100 into 30 bracket closed. per month. Full stop. Next para. Since the plaintiff's respondents have themselves claimed mean profits at the rate of rupees 100 per day and have not carried out any amendment, but rather are enjoying a decree which is passed as late as on April 20, 2024, comma, which fixes the upper limit of the mean profits at rupees 100 per day, comma, we cannot go beyond the prayer of the plaintiffs themselves by assessing occupation charges at a higher rate than the main profits. So, sub next para, it is trite law that the principle of calculation of mean profits and occupation charges under Order 41, Rule 5 of the Code of Civil Procedure, comma, as condition of stay, comma, are similar, comma, inasmuch as the main parameter for ascertaining both is the market rent which could be fetched by the plaintiffs at the relevant at the present juncture. Push up next para. Hence, comma, even giving maximum benefit of doubt to the claim of the respondents regarding mean profits, comma, the occupation charges of the suit premises cannot exceed rupees 3,000 per month. Pushed up, taking into account the above factors, comma, can 3 of 2024 is disposed of by granting stay of operation of the impugned decree, judgment and decree, as well as connected execution proceedings, comma, if any, comma, till disposal of the appeal, comma, subject to the appellant going on paying rupees 3,000 per month as occupation charges. Pushed up, the current occupation charges from the month of March 2025 shall be paid by the 10th of each current month starting from March 10, 2025. Full stop. The occupation charges, the arrear occupation charges from the date of the impugned decree till the month of February 2025 shall be paid at the self-same rate of rupees 3,000. Full stop. Such arrears shall be paid by 3 equal monthly installments, the first of which shall be payable also by March 10, 2025, and thereafter by the 10th day of each succeeding month. Full stop. In default of any of the payments, comma, the stay order shall stand automatically vacated without further reference to the court. Full stop. The payment shall be made. Mr. Poddar, your client's bank account can you disclose so that they can directly pay?
I don't know the bank account. After date of the original date, there was no payment.
কি বললাম? Payment shall be made directly to the respondents, but give a bank account, otherwise you cannot. At the bank account, at the designated bank account, comma, the particulars of which shall be furnished by the learned advocate for the respondents to his counterpart appearing for the appellant within a week from date in writing. Push up next para, such payments shall be subject to the final outcome of the appeal. Push up next para, in view, you appear for all the respondents. In view of the appearance of the respondents to their advocate, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The appellant shall, the trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice, of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Decree. That is the law. Next.
13, they not paid anything after date of the original date.
Yes.
Item number 22.
Well, this is a judgment of modification.
Judgment of modification.
Right. Because, my lord, it appears the principal defendant number 1 and defendant number 3 are the appellants before the lawsuit. Now, the suit for declaration that deed of gift is described in 4.1 schedule to the plaintiff void, inoperative and illegal.
Hmm.
With a further declaration that of the title of the property in respect of procedural property and permanent injunction. Now, my lord, it appears they have paid for half share of the property by inheritance, and my lord, the defense was that no, they only entitled to half share, and my lord, the trial court decreed the suit.
They sought a title for the entire property, regarding title to the entire property.
We are the joint possession.
No,
So, my lord,
their pair in the plaint was what? That they are
Yes.
the exclusive owner of the entire property.
Yes.
You said they are half share owners by inheritance.
Yes. Now the trial court decreed the suit in ex parte in part, and my lord, declaring that the plaintiff's right title interest to the extent of half. Appeal court reverse.
What about the gift deed? That was set aside.
That was deed of gift, my lord, is declared to be void.
Very well.
Declared to be void.
Trial court declared the gift deed to be void
and inoperative and not binding upon the plaintiffs.
Yes.
Now, my lord,
and also half share was declared.
half share. Appeal court declared 1/6 share.
You had preferred the appeal.
Yes.
They had not preferred any cross objection. But their share was reduced.
It's reduced.
What else? A gift deed remained void.
Yes.
So you are challenging the appellate court. You are saying that the gift deed is not void.
Not void, not and
what about 1/6 share? You are not challenging that portion.
No.
You said half.
We are considering that the joint property, the equal
On what
share.
premise did the appeal court say it's 1/6?
1/6, yes. Well, kindly look to
by calculating the shares of the numbers of people.
Yes. Well, kindly turn to appeal court judgment. Yes. Middle portion, this starts with the plaintiff number 1 as PW1 has deposed that Mrityunjay Badik, who is the original owner and possessor of the property described in constitutional plaint, Millard, and that the property described in co is the part of the constitutional. PW1 further stated during LR operation, certified copy of the final published LR record has been marked Exhibit 1, and evidence of PW has gained corroboration from Exhibit 1. On scrutiny of the written statement filed by the defendants, I find that they have also admitted the Mrityunjay since this was the owner. Admittedly, Mrityunjay was the original owner. There is no doubt. It comes out from the deposition of PW1. The Mrityunjay Badik died leaving behind wife was Usharani, defendant number 2, 5 daughters, and Sobarani, defendant number 3, Sobitarani, acquired 1/6 share in the suit property, and they have been possessing. So they have claiming that 1/6 share. Now, my lord, I find no reason to discard the unchallenged testimony of PW1, particularly when the written statement filed with the defendant highlights that defendants have not denied the plaintiff's title to the. We are not disputing that they have title. But PW1 has deposed on 31st August 2004. Mrityunjay has admitted Nandakumar Hospital on 8/9/2004. He was referred to Tamluk Hospital on better treatment. She has further deposed that according to PW1, defendant number 2, Mrityunjay Bank Badik, to Kochi Sub-Registry Office, got the deed executed and registered in collusion to scribe, witness, and judgment. Defendant number 1.
Yes, he was unconscious from 31st, cerebral infraction from 31st to 8th. He was hospitalized. 31st of August to 8th of September, he was hospitalized.
Yes.
And he died on the next day. How could he have executed a gift deed on 4th of September in the thick of that
4th September 2004?
2004 we are speaking about.
Yes.
All the dates are of 2004.
He died.
31st August, Mr. Rohit, on 31st
Yes.
August, he was hospitalized for cerebral infraction. He was there till 8th of September, 31st August to 8th September.
Yes.
And he executed the gift deed on 4th of September by going to the registry office.
Due to cerebral, yes.
It's palpably a fraudulent deed. Why should he interfere with the findings of both the courts? Concurrent finding of fact.
No, because one of plaintiff's appellant's share in the suit property described in court to the extent of 1/6 each, he is there.
They have been given less than what you said.
Yes.
You said they have half share.
They have half share.
But they were given less than that.
Yes.
So you cannot be aggrieved with that.
No. The defendant are permanently restrained from disturbing the plaintiff's joint possession.
Yes.
And kindly look to my ground of appeal. Kindly look to this. Here.
No, you claim by virtue of that gift deed.
By virtue of inheritance.
Gift deed, who executed the Mrityunjay executed a gift deed in favor of whom?
It is their allegation.
He executed
defendant number 1.
That is what we are asking you. That he gave the entire property to defendant number 1. So that has been declared void.
Yes.
Then what remains? The plaintiff's share to the extent of 1/6.
Yes.
Then what is the wrong in the judgment?
Wrong in the judgment is, my lord, when the trial court decreed the suit in respect of half share, then, my lord, the
1/6 is less than half.
Less than half.
So plaintiffs were given less than half.
Yes.
You are the defendant.
I am the defendant of 1. And
so how are you bothered? You are benefited by that if they are given less share.
Not only that, we have been restrained from disturbing the possession.
On the basis of that half
joint
yes.
property.
Yes, rightly.
And top of it, my lord, the appellate court committed substantial error of law in not holding that nowhere the execution of the registered deed of gift dated 8/9/2004 by Mrityunjay Badik has been challenged, and there was no plea of any false person implication. And regarding the execution of registered deed of gift.
Where is the written statement, Mr. Roki?
Yes. Just a minute.
Plaintiffs were there?
Plaintiffs, my lord, were
3 plaintiffs. So then appeal court did not modify it. It retained the order of the trial court. Trial court said half share for the plaintiffs together. There are 3 plaintiffs.
3 plaintiffs.
Appeal court says each of them has 1/6.
Yes.
That's right. If it's 3,
yes,
it has to be the half share has to be divided in 3. That was the basis of the calculation.
But the plaintiffs are 3, and defendant number 1 and 3. They though filed written statement but did not contest this suit.
No, in the written statement, they have not taken this point. Paragraph 21, they have not taken this point. Appeal court decides that.
Yes.
Appeal court also finds that.
And kindly go to take the ground number 4. Learned lower court committed substantial error in failing to appreciate that only thing challenged was the mental aspect of the executor Mrityunjay Badik in respect of deed of gift dated 8 September 2000. But the said deed was duly registered before the registration authority, and there is no allegation against the said authority.
Now let us see the written statement, Mr. Rokhi. The trial court did not declare the deed to be void.
Trial court?
Yes.
Trial court, my lord, yes, I'm placing that portion.
Rather, it is stated that nowhere execution by Mrityunjay Barik has been challenged, no plea of false personification.
Yes.
And plaintiffs also say that Mrityunjay Barik executed the deed.
Trial court held plaintiff has failed to prove sufficiently their contention in respect to the said registration document.
Yes, but the ordering portion come to the decree, Mr. Rokit, come to the
Yes.
trial court's decree.
Trial court decree
Instance
is
should be and the same is decreed ex parte in part without any orders to cost. Hereby declared that plaintiffs have right title interest to the extent of half share.
Half share.
So deed of gift was not held to be void by the
No,
trial.
no.
That was the appellate court for the first
Appeal
time
court,
did it.
appeal.
Just show us the written statement. You have a good case on that probably.
Appeal court.
Only the written statement, Mr. Rokit.
Just I'm trying.
ওই পয়েন্টে অ্যাডমিট করতে হবে দুটো কোটি বলেছি যে রেডি স্টেটমেন্টে কোথাও চ্যালেঞ্জ করে না
I do not find the written statement in my brief. I do not
But
find
written statement is the main document which is required to be seen.
I can.
No, let us just look at the recording of. No. In the plaint, please come to page 2 of the appeal court.
Appeal court judgment.
Yes, appeal court judgment, second paragraph. They have stated that at the relevant point of time, 80-year-old Mrityunjay Barik suffered cerebral ekhanta. Page 2 of appeal court. Suffered cerebral thrombosis and he was admitted to Nandakumar hospital on 31st and thereafter on 8-9 he was referred to. Everything is there. The pleadings are there. And he has adduced evidence on that. তাহলে তো রয়েছে প্লিডিং আপনি যদি এখানটা দেখেন এই act থেকে পুরো Mr. Rocky, there is no scope of interference, sorry. No scope of interference. The present second appeal has been preferred by one of the defendants and pro forma defendants in a suit for declaration that a gift deed executed by the admitted owner late Mrityunjay Barik in favor of the defendant number 1 stroke appellant number 1 was void, inoperative and not binding on the plaintiffs, as well as for declaration of the title of the plaintiffs and consequential permanent injunction. Full stop. Next para. The learned trial judge declared the shares of the plaintiffs to be half in the suit property, but did not grant any decree as prayed for in respect of the gift deed. Push up next para. However, the learned appellate court partially reversed the decision of the trial court by holding that each of the plaintiffs have 1/6 share and that the deed of gift was void, inoperative and not binding on the plaintiffs. Full stop. The premise of the learned appellate judge, the premise of the observations of the learned appellate judge regarding the deed was a sequence of events which was established by plaintiff number 1 as PW1. Full stop. The alleged donor Mrityunjay Barik was hospitalized between August 31, 2004 and September 8, 2004 in the Nandakumar Hospital due to cerebral infraction. Full stop. Thereafter, he was advised to be taken to the Tamluk Hospital and was discharged from the Nandakumar Hospital on September 8, 2004. Full stop. In the wee hours of the morning on September 9, 2004, that is the very next day, the said Mrityunjay met his demise. Full stop. The gift deed in question was allegedly executed on September 4, 2004, in the thick of the illness of Mrityunjay Barik when he was hospitalized. Full stop. Next para. Learned counsel appearing for the appellants argues that the learned appellate judge erred in law in reversing the findings of the trial court in the absence of any specific challenge to the registration of the document and or any pleading as to impersonation of the said Nandakumar. Full stop. It is further argued that the learned appellate judge traversed beyond the pleadings by passing a decree invalidating the gift deed, thereby reversing the trial court's judgment and decree to that extent. Full stop. Next para. However, on a perusal of the judgment of the appellate court, we find that there was clear averment in the plaint as to the said Mrityunjay Barik being an 80-year-old gentleman having suffered cerebral thrombosis and being admitted to the Nandakumar Hospital on August 31, 2004 till September 8, 2004 when he was referred to Tamluk Hospital for better treatment. Pushed up. It has also been averred in the plaint that the defendant number 1 in collusion with others took the unconscious alleged donor Mrityunjay to Khanchi, KHANCHI, sub-registry office from Nandakumar Hospital and got the so-called deed of gift registered. Pushed up. In fact, it has been alleged, Mrityunjay was not in a position on September 4, 2004, the purported date of the gift deed being executed, to execute the said deed. Full stop. Next para. Thus, we find the foundational pleadings, which provided basis to the evidence of PW1 to the effect that at the juncture when the gift deed was executed, the alleged donor Mrityunjay was not and could not be in a position to execute the gift deed. Full stop. Next para. The learned appellate judge has, by application of the parameter of preponderance of probability, has arrived at a conclusion which is otherwise plausible in the facts and circumstances of the said. case. Full stop. As such, comma, we do not find any reason to substitute our views for that of the first appellate court, comma, particularly since there is no legal or factual error or perversity in the judgment of the appellate judge. Full stop. Thus, comma, we do not find any substantial question of law involved in the present appeal. Full stop. Accordingly, SA 280 of 2014 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Accordingly, IA number CAN 1 of 2013, bracket old number CAN 9760 of 2013 is also dismissed without any order as to cost. Sorry, Mr. Next.
So I CAN number 1 of 2013 already disposed of.
What was that application? Not stay?
No, that was application
Dekhi.
restoration. That was allowed.
Acha.
By the Honorable Justice Biswi Basu.
No, CAN 3 was restored. CAN 3 was allowed. CAN 3 was for recall.
1 of 2013.
This is an application for recalling of the order. Justice Basu's order records that it was CAN 3 of 2021, which was a recall application, which was allowed. CAN 1 is your stay application. CAN 1 to ajli step here kuch nahi. CAN 1 is a stay application. Yes.
Number 23 and 24.
23 and 24, Lordship, I am for the appellants.
Yes.
Lordship, there are two appeals. One was out of time. Therefore, I filed a Section 5 application. Your Lordship directed me to serve. I served one of the envelope, came back with an endorsement.
I am for the respondent number 1, 2, 4 and 6, 7. 5 died, my lord, past time.
The heirs of 5 are on record?
No.
No, my lord,
Then you have to file substitution.
He has to
give the particulars to him.
in course of the day.
Course of the
Learned counsel. Learned counsel appearing for all the respondents, barring respondent number 5, submits at the outset that the respondent number 5 has died in the meantime. Full stop. Accordingly, the learned advocate appearing for the surviving respondents shall furnish the date of death and particulars of the heirs and legal representative of the said deceased respondent number 5 to the learned advocate for the appellant during the course of the day in writing. Acha, by tomorrow in writing. Full stop. Next para. The appellant shall accordingly take steps for substitution of the heirs and legal representatives of the said deceased. Full stop. Let the matter go out of the list for the present with liberty to the appellant to mention the applications as and when filed, comma, before the appropriate learned single judge having determination. Have it there and then come.
Item number 25 and 23.
My lord, in this matter, Mr. Raut is appearing, my lord. My lord, due to his medical checkup today, he has not come to court.
What?
Due to his medical checkup.
Medical checkup.
Throat infection due to heavy acute
Yes,
throat
yes, yes.
infection.
So,
only not today, my lord.
This is for the
Today
second
only
time I learned it,
medical
friend is taking the time.
pardon?
This was the second time I learned it, friend is taking the time.
Previous, yes.
No, it is admin, my lord. I personally, because I am junior, he
Mr. Chaudhary, you have to move
Yes,
the matter
yes.
if he does not come tomorrow.
My lord, yes, he will come, my lord.
On the prayer of the appellants, the matter is adjourned for the day.
Yes, my lord. Only not today, my lord. He has not come to court, my lord.
Please remind us, Ms. Mukherjee, on the next occasion.
Oh, my lord, yes.
Mr. Chaudhary, you will
Tomorrow,
move it.
tomorrow he will come.
Tomorrow you will move it if he does not come. Yes.
Grateful.
27.
27, the endorsement, the matter is defect.
Defect, what is the defect?
There are 3 defects.
Oh.
Deficit for fee, yesterday it has been paid.
Yesterday, actually.
Yes. And so far the valuation statement is concerned, it will be corrected, man, subject to Lordship's leave, my lord.
Valuation statement in the memo?
Memo.
Second, a third?
Third one, my lord, is my lord, Certified copy of the trial court judgment and degree was not filed. It is with me. If your lordship allow me.
Mr. Bhattacharya will direct the file to be sent to the department.
Yes.
Do those in the department. We'll keep it after a week with a fresh report.
If your lordship allows, my lord.
You'll file it here.
Yes.
Where we will take it on record?
19th is the fix for title execution. We can, if your lordship give leave, my lord, we can stay.
19th. But the difficulty, Mr. Bhattacharya, is that without a fresh office report, we cannot proceed on that, at least on the deficit court fee.
Deficit court fees, my lord, is the report is.
Where we will record. There's a hand it over, give a copy to us.
Yes.
There are, as pointed out by learned counsel for the appellant, there are 3 defects to the present appeal, one of which has been removed by deposit of the deficit court fees as borne out by the information slip handed over by learned counsel for the appellant in court today, Next para. The learned advocate on record for the appellant is granted leave to insert a valuation statement in the memorandum of appeal also during the course of the day.
And also in the application.
As well as the connected application during the course of the day. Next para. The what was the third defect you said?
Third defect, trial court.
The certified copies of the judgment and degree of the trial court, which are not filed previously, are filed here and now by learned counsel for the appellant and be tagged with the file.
It annoys, certificate. Yes.
And we tagged with the file.
Yes, ma'am.
Pushed up. In view of the extreme urgency involved, the appeal is being taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure, subject to the corrections as directed above being carried out by the learned advocate for the appellants, as well as a further report, a fresh report regarding the defects having been cured, being furnished by the office within a week from date. We are taking up the appeal for hearing under Order 41. But please carry out the corrections.
Yes,
even if you dismiss the appeal, please carry out the. Yes. Yes, Mr. Bhattacharya.
The defendant number 1, 1A and 1B is the appellant before the lordship. They are, my lord, the developer company. And the suit has been filed by the plaintiff is the broker. He has filed the suit for declaration, accounts, and, my lord, permanent injunction in respect of the agreement for sale.
Declaration, what declaration?
Declaration, my lord,
that the agreement for sale is valid.
Agreement is fine. Now, that suit has been decreed, appeal that has been, my lord, affirmed, and we have come up, my lord, with specific objection that section 34.
Both courts decreed?
Both courts.
You took the point of section 34. How was it dealt with?
Section 34 is not applicable because court has power, the plaintiff has power to bifurcate his prayer. So that is.
We'll just see the decree at least.
The decree, my lord, your lordship will.
Yes.
Decree, it is.
Decree that should be declared the only agreement.
This is not part.
No. That is the only ground on which you are.
There are other grounds, man, with regard to the contract that I have formulated the substantial point of law.
What are the other grounds?
Other ground, my lord, the agreement is question is unregistered, vague, indefinite, without any consideration, and, my lord, ambiguous and self-contradictory.
Agreement is
unregistered,
unregistered agreement.
vague.
Was registration applicable at that point of time when it
No,
was?
that not that. So far, the judgment of Justice Bhattacharya, that is not applicable because well, it was 94, 94.
But it was a compulsory registrable document.
Yes, yes,
Under Section 70.
71B.
71B. Unregistered and vague. Why do you say vague?
Vague, well, one paragraph it says something and the next paragraph it says something.
Contradictory.
Yes, well, self-contradictory.
Acha. And what else?
And my lord, ambiguous, no consideration. I have formulated the point of law, my lord, I am handing over to you.
And please hand over.
It is yours. No touch.
But mere mention of non-mention of period of completion does not render it. That will not
That
accept.
is well, according to me.
Why section 25 and 29, Mr. Bhattacharya, Contract Act to dinto? Indian Contract Act.
Please, no, change.
If you have one extra copy, you can just hand over. So we have. No, they one of the Din.
Your lordship got
25. Just give half a minute for my learned brother. Uncertainty, acha. 29 is uncertainty.
That will be decided at the final.
Without consideration, acha. No consideration is reflected from the agreement. Yes, Ash, Meghnad Ash. The present second appeal will be heard on the following substantial questions of law. Roman 1. Whether both the learned trial judge and the first appellate court substantially erred in law in decreeing the suit in the teeth of the same being barred under the proviso to section 34 of the Specific Relief Act 1963 in view of a mere declaration being sought regarding an agreement without seeking the further necessary relief of specific performance of the said agreement. Next, Roman 2. Whether both the courts below committed a patent error of law by granting a declaration in respect of a contract which on the face of it is without consideration and suffers from uncertainty, thus acting in contravention of sections 25 and 29 of the Indian Contract Act 1872. These two grounds we are admitting, this will cover model.
Stay application.
Yes, stay application. Stay application, section 5 was allowed previously.
Yes.
Stay of operation.
Title execution.
Oh, execution has been left. That has to stay.
Property has been added.
Who are you? Supporting the case of the appellant. Achha. You are the broker, you are the villain here. You're supposed to be the villain here. We don't know whether you are. No, you have mentioned the execution case number?
Yes, yes.
Very.
5 of 2022. Where your lordship will get it. Can 2.
Yes, can. So dispose of the application. In view of the admission of the appeal, it is obvious that a prima facie case for hearing the appeal on merits have been made out, full stop. Accordingly, Can 2 of 2025 is allowed on contest, comma, thereby granting stay of all further proceedings in title execution case number 5 of 2022 pending before the learned civil judge senior division additional court at Hooghly till disposal of the appeal. Push up next para. The appellant shall, now in view of the appearance, all the respondents are represented.
No. There are
You are
other-
5 and you are for one series.
There are other respondents.
Acha. In view of appearance of the respondent numbers 1 to 3 and 5 through their respective learned advocates, comma, এই লাইনটা কেটে দিন। Learned counsel having instruction to appear for the respondent number 5 seeks leave to submit vokalatnama on behalf of the said respondent during the course of the day, full stop. Learned counsel for the respondent numbers 1, 2 and 3 also appears, and as such service of notice of the appeal on the respondent numbers 1, 2, 3 and 5 is dispensed with, full stop. The appellants shall deposit due postal costs and other requisites for service of notice of appeal on the absentee respondents within a week from date, full stop. The appellants shall prepare and file informal paper books within 4 weeks from the date of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop next para. The trial court records be brought by special messenger at the cost of the appellants to be deposited by within a week from date. Full stop. Liberty to the parties to mention the appeal for hearing before the appropriate learned single judge as and when the same is ready for hearing.
And it
Wait a
should
minute.
come after the stamp report or further report before your lordship.
Further?
Report you regard. Should it come?
No, we have started.
Yes.
We have started. প্রথমেই তো বললাম যে সাবজেক্ট টু
Yes, ma'am.
এটা অফিসে পাঠিয়ে দেবেন, বলবেন যেটা প্রথম প্যারাগ্রাফটা দেখে রিপোর্ট করে দিতে। Need not come here. Thank you.
Number 28.
28 my lord, I am
Give us half a minute. Specifically একটা একবার দিন তো এই উপরেরটা। Just give us half a minute.
Yes, yes.
ল্যাঙ্গুয়েজটা 34 এর আদার না দেখে নিই। হ্যাঁ, further. Yes.
My lord, I am for the appellant.
Yes.
My lord, judgment of reversal.
Judgment of reversal. Right.
My
What
lord,
is the defect?
Defect, my lord, court fees we have paid. On the last occasion, my lord, we have referred to that we have paid the court fees and
Press
report
report was to be directed to be given.
Yes.
Press report দিয়েছে, স্ট্যাম্প রিপোর্টটা পাঠিয়েছিলেন না? কোথায়?
রিপোর্টটা বার করুন।
Since the deficit court fees have been paid, but beyond time, comma, we accept the, we condone the delay in putting in the deficit court fee and accept such deficit court fees, full stop. Accordingly, the defect in respect of filing of the appeal is deemed to stand cured, full stop. The appeal is taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes, sir.
My lord, there are 3 grounds for eviction. One is default, one is reasonable requirement, and another is.
You are the defendant.
No, I am the plaintiff.
Oh, default reasonable requirement
and creating nuisance and annoyance.
Right.
So, but the default ground is concerned, my lord, in all the 3 grounds, we succeed in the trial court, but
Right.
it was upset by the learned appeal court, first appeal court, learned 11th bench city civil court. But so, but the ground of default is concerned, my lord, it is our specific case in the plaint that he is a defaulter since January 2003. As against that,
this is a Premises Tenancy Act.
Yes. As against that, my lord, I am placing the 7.1 and 7.2 application, 2 applications, handwritten application, no dispute, nothing. And it was found that there is a default of 99.
Second judge's copies.
Yes.
Both copies have been given?
Yes.
Good.
And it is found, yes, no dispute has been raised.
They say determine the areas of rent.
But
No
it was
dispute.
no dispute, and it was found that 99 months rent has not been paid by the 7-2 order.
All right.
And the learned trial judge held that since you have not complied and you have not raised specific dispute and you have not complied with 7(1)(a) and B, so 7(4) protection is not there. And my lord, perhaps my lord, based on the judgment of Vijay Singh case, my lord.
Otherwise, if 7(2) is filed, 7(1) merges into 7(2).
But no dispute is raised.
If no dispute is raised, you say that's an illusory application.
Yes.
Then there is no question of margin.
Yes. Either he has to say that I have deposited.
Very interesting point.
Or I have paid rent, no receipt granted, nothing of the sort.
Which paragraph of this?
My lord, para 21. This is a mandatory provision, my lord. Otherwise, he cannot even get the benefit of section 7(4). Even section 5 has got no application.
No.
And 7(4) protection is subject to compliance of 7(1)(a) and B. This finding was upset. So far the default ground is concerned.
All right.
And my lord, so far the reasonable requirement is concerned, my lord, it is my specific case that I am a businessman. I have got a sweetmeat shop in a rented house. So in the ground floor, there was a local inspection. It was found by the trial judge that at admitted position that in the ground floor there are 3 rooms, 2 in my occupation used by the workers as their residence. Because they are working with me, document has been exhibited, exhibit 10 that
sells sweetmeats.
Yes, in the Gonastok area, my lord, this is a famous sweetmeat, and I have trade license, salary slip.
Have you been paid in kind or in cash? Sweetmeat shop.
No, I'm always purchasing, my lord, by cash. My lord, he's coming with sweets, my lord. That's different issue. Whenever I am visiting, my lord, I am paying. This is my principle.
Obviously, you will. that we are confident of that. So what about this?
And learned.
How did the appellate court?
Appeal court held that you have to adjust.
What? Who was that finding?
My lord, kindly come to that findings. My lord, page 7. Page 7 of the appeal court judgment. You adjust. Page 7 and 8. Seven, 8, and 9. Vital para, my lord, page 9, first para, last 6th line. Thus, the plaintiff landlord can well adjust themselves in the existing available accommodation without getting the possession of the tenanted premises. In the first floor, my lord, there are 2 rooms and my family 5 members. He said that you adjust.
Yes, what about the third ground? Nuisance,
my lord.
This appeal shall be heard on the following substantial questions of law. 1. Whether the learned first appellate court substantially erred in law in holding that the defendant stroke respondent is not a defaulter in payment of rent, inasmuch as the purported application filed by the defendant respondent under section 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997 was an illusory application, and in the absence of any dispute raised regarding the rent payable, comma, could not be treated to be an application under the said provision, comma, in view of which the defendant ought to have been held a defaulter due to violation of the mandatory provisions of clause small a and clause small b of section 7 within bracket 1 of the said act. Roman 2, whether the learned appellate judge committed a palpable and substantial error of law in observing that the landlord that plaintiff stroke landlord could adjust his accommodation within the available rooms, comma, which is contrary to the settled principle of law that the court has to sit on the armchair of the landlord in ascertaining the requirement of the landlord and in overlooking the other facets of requirement of the landlord as a whole. To sub next para. So we'll direct you to put in
Yes, yes. No stay, nothing.
no question of stay. The appellant shall put in requisites within a week from date for service of notice on the respondent, full stop. The trial court record be brought by special messenger at the cost of the appellant, which shall also be deposited within a week from date, full stop. The appellant shall prepare and file the requisite number of paper books within 4 weeks, requisite number of informal paper books within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who's of liberty to the parties to mention the appeal for inclusion in the list before the appropriate learned single judge as and when the same is made ready for hearing.
Grateful.
Next item. What is your prayer? আচ্ছা 29 বোর্ডে দেখিয়ে দিন একবার Yes, yes, please do that. Please do that. At least one copy.
Yes, yes.
Item 29 on the prayer of the appellant, the matter is adjourned till February 24, 2025.
Or I am for the respondent.
I'm grateful for accommodating.
Thank you. Yes.
Final degree in connection with the partition. Sir. Objection was filed in connection with the, my lord, the commissioner report. Without, my lord, disposing of the same, practically no reason, nothing of the sort, final degree has been passed.
No
Yes,
opportunity to cross-examine the commissioner.
nothing. Only said that it is a evasive
What is this application for?
application for stay. And on the last occasion, your lordship admitted and passed an interim order to that effect and directed to serve copy. They have filed.
Yes, what do you say?
Not only a grievance of the of my learned friend is that the report that has been submitted by the commissioner
Yes.
is not up to the mark, or against that, my lord, my learned friend's client, my lord, filed an objection. His allegation is that no, my objection was not been heard. That is only. If that be so, my lord, in that case, I am submitting before your lord
Remand.
only to remand back and to hear the.
Very fair submission.
Yes.
Very fair submission. Then we can, on consent, we can take up the appeal. We'll set aside. We'll remand and direct the learned trial judge to take into consideration his objection and grant opportunity to cross-examine the commissioner. If everybody was so fair, it would be very good. Yes.
And another thing is
Yes.
that when the, my lord, the preliminary degrees for partition meets and bounds, but he has overstepped it. By
That will not go into that because the objection.
all right. All right.
While hearing the application for stay, comma, we find that the appeal has been preferred. Yes.
No.
The appeal has been preferred against a final decree of partition. The grievance of the appellant is that the learned trial judge passed the final decree of partition, which is impugned herein, comma, without taking into consideration the written objection to the commissioner's report filed by the present appellant, as well as without granting any opportunity to the plaintiff stroke appellant to cross-examine the commissioner. Next para. Learned counsel appearing for the respondent takes an extremely fair stand and submits that he has no objection if the appeal itself is taken up for hearing in view of the limited question involved. Next para. Accordingly, comma, we take up the appeal itself along with the application for hearing by dispensing with formal preparation of paper books and calling for the records. Accordingly, upon hearing learned counsel for the parties, comma, FAT 256 of 2024 along with FA 88 of 2025 along with CAN 2 of 2024 are disposed of by setting aside the impugned judgment and decree and remanding the matter to the learned trial judge. The learned trial judge shall, comma, upon consideration of the written objection filed by the plaintiff appellant to the partition commissioner's report and granting opportunity to the parties to cross-examine the partition commissioner, comma, pass a fresh final decree of partition. Next para. It is made clear that the merits of the contentions of the parties otherwise have not been entered into by this court, and it will be open to the learned trial judge to enter into such all such issues independently in accordance with law without being influenced in any manner by any of the observations made above. In view of the long pendency of the suit, comma, it is expected that the learned trial judge shall expedite the hearing of the suit after remand.
Yes.
As far as the business of the said court permits. A formal decree be drawn up according, decree hobe na, remand. No orders to cost. Thank you very much. Thank you.
The dispute is settled by this way.
Yes, because this is the most rational approach. Yes.
Dispute between the two brothers.
Both parties would litigate for 10 years and after that this decision would be taken. Yes. Thank you. 30 yes.
I am for the petition.
Yes.
I am for the respondent.
Yes, Mr. Roy, here also we are remanding them. What is the challenge against?
My lord, this is a suit for eviction of a licensee.
We wanted a revised office report. কোথায় সেটা? আগের বার রিপোর্ট দিতে বলেছিলাম, দেয়নি, ওই জন্য আবার বলেছিলাম। অফিসকে ইন্টিমেট করা হয়েছিল তো? আগের বার এটা হয়নি বলে আবার চেয়েছিলাম আমরা অফিস রিপোর্ট। দেখি yes
But this is a
the appeal arises sorry please continue suit for
first appeal arise the suit was for
eviction of licensee.
licensee, which was allowed. Against that, we have filed an appeal before the learned district judge, and that appeal was dismissed on the grounds of Section 5 delay. Against which we have filed this appeal. So technically, my lord, this is a
Section 5.
Section 5.
So then we were correct, Mr. Rai. In any event, you have to remand it ultimately. So what was the ground? Why was it dismissed? Let us see the judgment of the appellate court. What was the delay?
Delay was 41 days.
41 days not unknown. Which is the relevant portion of the appellate court judgment? Which was that?
But that is the last order. That is order number 5 dated 4/10/2023. Last page. Appellate court service. Is the third paragraph, my lord.
No, there's a sorry, we are looking into the suit.
Order dated 4th October, probably.
This where is the appeal court judgment?
4th October 2023. Order. 4th October 2023.
Order
The
certificate.
memo of appeal might contain the original order.
Yes, we are on the memo.
Because trial court judgment and order was submitted later.
Oh, that's why we are all. Thank
One page.
Yes, yes.
One page.
But
Spiritual person.
Spiritual ground we are not taking, but that cannot be a ground. We are condoning the delay so that that chapter is over, and we are directing the
appeal to be disposed of within that time frame.
In view of the limited point involved, we take up the appeal. Sorry, order for tenure formally admit. The present second appeal shall be heard on the following substantial question of law: whether the learned appellate judge gave a go-by to the well-established liberal principles of law in respect of adjudication of applications for condonation of delay in dismissing the appellant's application for condonation of delay in preferring the title appeal only on the premise that no one can plead ignorance of law to defend his or her actions, without adverting to the averments made in the application for condonation of delay at all. Push up next para. Upon consent, on consent of the parties, in view of the short point involved, the appeal along with the application is taken up for final hearing. Pushed up, the necessity for calling for the records and or preparation of formal paper books is dispensed with. Pushed up next para. We find from the records that sufficient reasons for the delay in preferring the appeal, title appeal number 6 of 2023 was furnished by the appellant in his application under Section 5 of the Limitation Act. Pushed up, although ignorance of law might not be a valid ground, even apart from that, sufficient justification for the delay in preferring the appeal has been made out in the application for condonation of delay. Full stop. Accordingly, SAT 37 of 2024 is allowed, thereby setting aside order number 5 dated October 4, 2023, as well as the consequential decree passed by the appellate court and remanding by allowing the application under section 5 of the Limitation Act and condoning the delay in preferring title appeal number 6 of 2023. Full stop. Next para, the matter is remanded to the appellate court for adjudication on merits. Full stop. Next para, it is expected that the learned appellate judge shall dispose of the appeal as expeditiously as the business of the appellate court permits, comma, preferably within 8 months from the date of communication of this order, of this judgment to the court will.
There is also an execution pending by which has.
They have to pray for stay and the condition will be imposed there. Now, my lord, the appeal is.
Liberty is granted to the appellant to pray for stay of the connected execution case before the first appellate court, because we are no longer in season of the matter. Okay. This should be revisited by the Supreme Court.
The only one word, only last paragraph, 3 lines. What is the use of, because enter thing, my lord, only restricted to section 5, then I have to remand it.
This should be revisited by the Supreme Court. Anyway.
Special ways to আমাদের issue.
Yes, but what can be done? Yes, next matter.
Yes, Lord, there is one defect, Milord, reported.
Item has been called on. Which is the item?
31.
31.
Milord,
yes. What is the defect?
Yes, what happened, Milord? We prepared the cost title from the plaint. Now, Milord, after the decree was drawn up much later, Milord, what happened in before when the title appeal was pending, 3 persons had expired. They are, we had, Milord, included the name of the dead persons. Their heirs are already there in the decree. I have to include the name of the heirs.
No, but it is time barred against them then now. File a formal 1-page application.
Can one, Milord, is one application, Milord, for leave to present the memorandum of appeal against the respondent number 4. Milord, he died after the decree and before filing.
Oh, after the decree?
No, these are those persons were during the pendency of the title appeal. They were substituted. Okay. Now, Milord, we came to know respondent number 4, Milord, died, Milord, after the decree and before this appeal.
His heirs?
Heirs, Milord, I have stated in Can 1, Milord, the 4 A, B, C, C1, C2, Can 1.
We will allow this application. Can 1 of 2024 has been filed for leave to prefer the present second appeal against the heirs and legal representatives of the original respondent number 4 who has died after the passing of the judgment and decree by the first appellate court and before presentation of the memorandum of the present appeal. Push up next para. In view of the application being otherwise informed, comma, Can 1 of 2024 is allowed, comma, thereby granting leave to the appellant to prefer the present second appeal against the heirs and legal representatives of the respondent number 4 as named in the cause title of the present application. They are already parties to your memo.
Yes.
Push up next para. It transpires from the office report, very well will permit you. Transpires from the office report that although but respondent number 4, the office report says respondent number 4 died and his heirs are recorded.
Yes, respondent number 4, Milord, Nihar Ranjan Pal.
But his
office
after the
after.
Oh, all right. So then that takes care of that defect.
That defect, yes. And then Milord regarding
others also. 2A to D and all.
Yes. 2, then Milord 21, 29.
It transfers from the office report that the appellant has not impleaded respondent numbers 2 within bracket small a to small d, comma, 21 within bracket small a to small c bracket, comma 23 ওই a b গুলো সব ব্র্যাকেটে হবে, এটা ব্র্যাকেটে b, 23 a and b as well as 29 a and b of the decree of the first appellate court. Full stop. Accordingly, leave is granted to the learned advocate on record for the appellant to carry out the necessary amendments to the cause title of the memorandum of appeal by incorporating the names of the said respondents in the memorandum of appeal as well as the connected application during the course of the day. Full stop. Can 1 of 2024 ke allowed bolechi? Disposal is allowed by leave টা যেখানে প্রথমে do that. We'll place the appeal for hearing under order 41 tomorrow. Yes. You have to carry out the corrections today.
Day after tomorrow, my lord. It's a
Very well.
long cost.
Very well. The appeal shall be placed in the list for hearing under order 41 rule 11 of the Code of Civil Procedure on February 19, 2025. Oh, sorry. Day after tomorrow 20 হচ্ছে February 20. Thank you. That is the appeal hearing day, but it will be in the list.
Madam, for the appellant, but I'm paying for a week's time, but there's a defect with regards to court fee.
Pardon?
There's a defect with regards to court fee. We need to deposit the requisite court fee, but
Any other defect? Let us check up. If there's any other defect, we will give you liberty to do that also.
also need to serve the other side.
Certified copy of judgment and yes, you have filed it subsequently. Certified. Deficit court fee, it is not reflected here.
It is written in the cost title. There is some certain defect we have to
Effective deficit court fee, yes. There are two appeals.
My lord.
Achha, in one of the appeals, there must be deficit court fee.
No, in both.
Both? 32 and 33. হ্যাঁ, কিন্তু এখানে এটাতে কেন ডেফিসিট কোড ফি বলছে? অ্যাপিলটা দেখুন। On the prayer of the appellants, comma, the appellants are directed to deposit the deficit court fees within a week from date, full stop. A revised report in that regard shall be filed by the office and tagged with the main file, full stop. The matter be placed in the list under the same heading next on March 10, 2025. Let the office prepare the report in the meantime. Officer Namir.
Item number 34. For the appellant.
Current body, yes.
Matter, my lord, a caveat has been lodged, my lord. So I have to serve the copy of the.
Why haven't you served? You mentioned the appeal. Before that, you should have served the copy of this stay.
The advocate.
Yes.
Was ascertained a few days back, my lord. Some
Monuruzzaman.
Something. Somehow.
Here it's written Monuruzzaman. On the prayer of the appellant, the matter is adjourned for the week and shall next be listed on February 25, 2025 to enable learned counsel for the appellant to serve a copy of the connected application on the learned advocate for the caveator. Yes.
Somebody appearing for
My
the
lord, in this
respondent, my lord.
matter, I appearing beg to appear on
Yes,
behalf of
yes,
the
we see her. Yes.
respondents, my lord.
35.
Aviator.
Yes, Ms. Maitri. Mr. Ghosh, second appeal, yes.
Yes, my lord, last occasion, your lordship, for scarcity of time, the matter could not
Paucity
be.
of time,
Yes.
right.
Paucity of time.
You just please remind us what is that?
Lord, what
Your
happened?
lordship, kindly, my lord, if your lordship permits me, my lord, two documents I want to show your lordship. Your lordship, whatever
At
your
this
lordship is
stage-
binding upon me.
Ms. Maitri, you don't have a right of hearing.
No, that's true. That I do admit, my lord. Still subject to your lordship can sanction. Let my undertaking finish there, then I shall.
Yes, Mr. Ghosh, what is that?
This a declaratory suit was filed by the appellant before your lordship to declare that the transaction in question is not an exchange but it is a sale. And it has been done collusively, solely with the intention to deprive the appellant from exercising the right of preemption under Section 8. As admittedly, he is a co-sharer in respect of the plot. Lord, simultaneously, he filed an application under Section 8 and 9 of the West Bengal Land Reforms Act, and that was registered as a miscase of 1 of 17. Lord, after getting notice of the preemption case, and Lord, this suit was also filed on the same day, the respondent number 1, who is my co-sharer and exchanged the property, he filed a suit for declaration that that transaction is a void transaction, it has not been acted upon against the transferees by exchange. Those are third parties. Now respond number 2 to 4. And within Lord 77 days, the said suit was decreed ex parte. They didn't contest. Well, obviously, they didn't contest, and it was decreed ex parte. Well, after that only, the respondent number 1 appeared and filed his written statement pointing out that I have got a degree. Ultimately, Lord, in the suit, the defendant number 1 alone, both the defendants, both sets of defendants, number 1 and 2 to 4, they filed separate written statement. But ultimately, the defendant number 2 to 4 didn't contest the suit. And accordingly, the defendant number 1 contested it, and ultimately the learned trial court declared that the transaction in question is sale in the guise of exchange, and the degree is void.
So your suit was decreed?
Suit was decreed. They preferred an appeal. Who preferred the appeal? Now both of them jointly. Jointly preferred an appeal before the appellate court, but appellate court has reversed the judgment and degree. That is the subject matter of appeal before your lordship.
On what ground? Reversed?
Lord, reverse, Lord, your lordship, if your lordship goes through the judgment, Lord, he has made a mess. He has recorded, Lord, every mistake, and he has discovered something which is not the pleading of the parties, and Lord, only he quoted certain judgments and the sections, and ultimately allowed the appeal. Your lordship, can you see, I am pointing out.
So what about the first decision with reasons, whether the same court can set aside its own judgment?
Lord, your lordship, that is if it is collusive and fraud.
What is collusive and fraud? Which suit?
The earlier suit.
You also sought a declaration that...
Yes. That is in collusion and fraud.
You did not say that. You said that you only sought a declaration that it's a not exchange but sale. You also sought a declaration?
Also, subsequently by amendment when it was noticed.
Say that, yes.
It was done. Lord, your lordship, kindly see what is the nature of exchange. The nature of exchange is not the...
What was the court's finding, appellate court finding on whether it can recall its own order?
Lord, that is, Lord, he said that we have not given any provision. We have not given any provision, we have no right. Because, Lord, he has somewhere recorded that we are also parties to that suit. It is not at all factually correct. We are not parties to that suit.
But did you take a ground of fraud?
Yes, we have taken the ground of fraud. Lord, therefore, Lord, your lordship knows, Lord, 94 Supreme Court was cited that at any stage in any proceeding, it can be in collateral proceeding, it can be challenged. No, but learned court below, in spite of citing of the judgment, he has said no provision has been cited. No, kindly see entire judgment. There are so many mistakes, and though the DW1, he has admitted that talk of sale was held, and ultimately it was registered as an exchange deed. Lord, total property of our co-sharer was 42.5 decimals. And that exchange he got only 10 decimals.
Mr. Ghosh, we find most of the judgment dedicated to the provisions of law.
Provisions of law.
And that was on the first question, whether can set aside its own judgment.
Yes.
What was the appeal? How did the appellate court reverse the trial court's finding regarding it not being a exchange but a sale? What was the finding on that?
Lord, he has heard that section 118 of the Transfer of Property Act, all the ingredients of exchange are there, therefore it cannot be treated as a sale. And now kindly see the nature of transaction.
How did the trial court deal with that?
Lord, your lordship, kindly see.
Let us start with the trial court once, Mr. Ghosh, regarding that deed of sale.
Yes. Lord, your lordship, kindly come to.
Because trial court must have granted both decrees to you.
Yes.
Decree set aside.
Yes, yes.
So how did the trial court deal with that sale? Let us find.
Lord, kindly see this one. Your lordship will come to issue number 8. That is regarding this judgment.
Yes.
The plaintiff alleges that judgment and decree dated 28th April 2017 and 18/5/2017 respectively passed by the learned court of civil judge junior division second court Kamdu in titles number 43 for the year 2017 is illegal and void, as the same is vitiated by fraud. The plaintiff further alleges that the suit was filed by the defendant number 1 against the defendant number 224 on 10th February 2017, whereas he had instituted the instant suit on 17/1/2017 to get the said exchange deed declared as a sale deed. He further averred that in the said suit, the defendant number 1 obtained a collusive ex parte decree with the help of the defendant number 224, declaring the exchange deed to be inoperative. As such, the plaintiff alleged that the said judgment and decree be declared as illegal and not binding upon him. The defendant number 1 alleged that the exchange deed was not executed according to the terms agreed by him and the defendant number 224, and as such, when he came to know about the fraud practiced upon him, Lord, he also alleged fraud against the defendant number 224. Lord, now, Lord, the appeal has been prepared jointly. This appeal, the appeal before the learned trial court. He filed suit praying for a declaration that the exchange deed is void. He further alleged that this learned court was pleased to pass an ex parte judgment in his favor, thereby declaring that the exchange deed is inoperative in the ILO. The defendant number 1 contended that the plaintiff was not a party to the said exchange deed, and as such, he has no right to claim the exchange deed a valid. The defendant number 224 also supported the version of the defendant number 1, alleging that the plaintiff was not a party to the exchange deed, and as such, he has got no right to contend that the same is sale deed and not an exchange deed. They further allege that the plaintiff does not have any locus standi to challenge the judgment and decree in titles number 43 of 2017, which has been decreed in favor of the defendant number 1, and he was not a party to the said suit. They further contended that the said deed was not executed as per the agreement between them and the defendant number 1, and as such, the said exchange deed is null and void. In this regard, I have already I have already opined in the above mentioned point that there appears to be some collusion on the part of the defendants. Furthermore, it is a matter of fact that title number 43 of 2017 was instituted after institution of the instant suit, and as such, it can be very well established that the defendant had knowledge about the suit. The second most important factor is the conduct of the defendant number 224, who did not appear in title number 43 of 17, but appeared in the instant suit. Upon perusal of Exhibit 4, it can be seen that title number 43 of 2017, the defendant number 224 did not appear even after service of summons, and as such, the said suit proceeded ex parte against them by order dated 14th March 2017, but at the same time, it can be seen that the defendant number 4 appeared in the instant suit on 22/2/2017. Thereafter, the defendant number 224 filed their written statement in the instant suit on 29/7/2017. and contested the instant suit by supporting the version of the defendant number 1. The defendant number 1 has alleged that the defendant number 224 claimed the exchange property, that is 42.5 decimals in plot number 1751, and denied his title over.
Mr. Ghosh, you were a party to that suit.
No, I was not made a party. Obviously, after filing of the preemption case as well as the suit, challenging the deed of exchange, that it is in fact a sale deed.
So we are on a different point. If you are not a party to the suit, can you challenge that decree on the ground of fraud? You may add a declaration that it is not binding on you.
I said that that degree.
How can you say that a decree is fraud if you are not a party there?
But because the suit, after filing of my suit, challenging the deed of exchange, he got notice of it. And thereafter, he filed the suit. And within 4 months, within 77 days, he got an ex parte degree in absence of the contesting defendants. And he has said
that will collaterally affect your suit.
Yes.
But that does not mean that you can seek a declaration that the degree is not initiated by fraud. If you are not a party to the degree, you have no locus standi to file a suit seeking declaration that.
This is my point.
But that degree.
My brother and I file a suit between ourselves and get a collusive degree.
Yes.
You are not a party there.
But that degree is used.
What is your locus standi to seek a declaration that this degree is obtained by fraud?
After filing after filing the written statement, they have taken in defense the said degree. They, as soon as they take as defense in their written statement the said degree, use the said degree as a defense. But I pointed out that it has been done with the knowledge and without disclosing that a suit is pending challenging the deed of exchange. He should have disclosed it before the learned court below. That yes, there is a suit challenging the deed of exchange. And I am the most affected party because I am the co-sharer. I intend to purchase the property. Your lordship kindly see.
It's collateral. Collaterally, consequentially, you are affected. If that degree goes, there is no sale deed, you cannot get a right of preemption at base.
Yes.
But how does that entitle you to seek a declaration that a decree between two other parties is fraudulently obtained?
Because your lordship kindly see the collusion, the defendant number 224 didn't appear there, and it allowed it to be ex parte. And thereafter using this ex parte degree in this suit, now they are both saying that it is a. And what happened? The preemption case, after filing of the preemption case, when this was done, we prayed for stay of the preemption case, awaiting the order in the title suit. But the matter matter was that application for stay was rejected, and we moved this honorable court. This honorable court in revision held that it has been rightly refused to be stayed, but you can, after the decree in my suit, declaratory degree, you can make another application for preemption, and limitation will not be barred. On the finding of that, I challenged that degree also by amendment of the plaint. And kindly see what happened in the factual aspect of the matter. 42.5 decimals was exchanged in exchange of 10 decimals. That is also far away from the property which our co-sharer defendant number 1 was owned and possessed. That is in his village, that is Kakra. And the exchange property is another village, in another police station. And valuation of the defendant number's property is 4,80,000, whereas the property exchange valuation is 80,000. And kindly see in the evidence, he has admitted there was talk of sale. But ultimately, it was a deal of
Suppose how did the trial court deal with issue number 5, which was the other issue? Let us see that also. Page 10 of the trial court.
Yes.
That is your primary relief, I mean.
Yes. The plaintiff filed the instant suit alleging that he is the owner in respect of procedural plot. The plaintiff has, in this regard, contended that the suit plot originally belonged to Suval Chandra seat. He has further alleged that he purchased 13.18 decimal land in plot number 1751 from the Chandra, who had sold in number second. In this regard, I have gone through the exhibit 2, which is the certified copy of the sale deed executed by Amalendra Chandra in favor of the plaintiff Manoj Kumar Bab. The plaintiff has also provided the certified copy of the various deeds by which Amalendra Vikas Chandra had purchased the suit property by different deeds which have been admitted in evidence and marked as 6, 7, 8, 9. Furthermore, the defendant have not raised any objection against the same, and as such, it can be safely held that the plaintiff has right title interest over co-scheduled suit property. The plaintiff has also alleged the exchange deed mentioned in co-schedule regarding the co-1 suit plot is a sale deed and not an exchange deed. In this regard, the plaintiff has alleged that the defendant number 1, Shashabindu Pradhan, and the defendant number 2 to 4, namely Joydev, Gurubodo, and Tapos, executed the said deed to defeat the right of preemption of the plaintiff. The plaintiff further alleged that by virtue of the said exchange deed, defendant number 1 transferred 4 and half decimals land having a valuation of 4,80,000 in plot number 1751 of Mauja Kulu in exchange of 10 decimals land having a valuation of 80,000 in plot number 6591 of Mauja Kakra. The plaintiff next averred that the stamp duty in respect of the exchange deed was also paid upon rupees 4,80,000, and as such the same was a sale deed and not an exchange deed. The plaintiff further averred that the defendant number 1 got the said deed registered at Bhagavanpur ADSR secretly, so that no one could know about the exchange. And the plaintiff also contended that the defendant number 2 to 4 had purchased 33 and 2/3 decimals of land in plot number such and Mauja Kakra at a consideration of 7,27,000. And as such, they had no reason to exchange 10 decimals of land at a valuation of rupees 80,000. The plaintiff also alleged that the attesting witness in the said exchange deed is the son of the defendant number 1, namely Uma Shankar Pradhan. The defendant number 1 and 2 to 4 filed their respective written statement, thereby alleging that the said exchange deed is not a sale deed as alleged by the plaintiff. Defendant number 1 alleged that the defendant number 2 to 4 practiced fraud upon him and made him execute the said exchange deed, by virtue of which the defendant number 2 to 4 got 42 and half decimals of land in plot number 1751 in exchange of defendant number 1 getting, in exchange the defendant number 1 getting only 10 decimals land in plot number such and such. The defendant number 1 further alleged that the said exchange deed was supposed to be executed in respect of 60 decimals land of the defendant number 2 to 4 in exchange of 42 and half decimals in plot number such and such. The defendant number 1 further contends that he had executed the said exchange deed considering the defendant number 1, 2 to 4 was transferring 33 and 2/3 decimals of plot number such and 26 and 1/3 decimals in plot number such and such, having total area of 60 decimals to the defendant number 1 in exchange of 42 and half decimals of land. The defendant number 1 further averred that he had signed on the said exchange deed without going through the contents, and he had very cordial relation, as he has very cordial relation with the defendant number 2 to 4. He has further alleged that he used to teach the defendant number 2 to 4 and knew them since their childhood days, and as such, he had no reason to disbelieve the defendant number 2 to 4. He has further alleged that when he came to know about the fraud that was practiced upon him by the defendant number 2 to 4, he instituted a title suit number 43 for the year 2017, which has been decreed ex parte, and the said exchange deed has been declared illegal and inoperative in the eye of law. As such, the defendant number 1 has contended that at present the said exchange deed is not existing, and the plaintiff does not have any right to allege that the same is a deed of sale and not an exchange deed. The defendant number 2 to 4 allege that co-1 schedule suit property is the property of defendant number 1, who is still in possession of the same. They further averred that they had a conversation with the defendant number 1, by virtue of which the exchange deed was supposed to be executed in respect of 60 decimals of defendant number 2 to 4 in exchange of 42 and half decimals of land of the defendant number 1. They have further contended that the exchange deed dated 21st October 2016 is illegal and cannot be acted upon, as the same was not executed as per their conversation with the defendant number 1. They have also alleged that the said exchange deed was not a sale deed as alleged by the plaintiff. They further averred that the said exchange deed is a null and void and inoperative in the law. In the instant suit, the plaintiff has alleged that the exchange deed is a sale deed, and as such the same has to be inferred from the circumstances, because there cannot be any direct evidence regarding the same. The action and conduct of the defendants are the most important guiding factor which will help this court to decide the instant issue. The first most important question that arose before me, that why would a person transfer 42 and half decimals in exchange of 10 decimals land? The defendant number 1 has in this regard alleged that fraud was practiced upon him, but it can be seen that the defendant number 1, Shashabindu Pradhan, was a retired high school teacher, and one of the attesting witnesses of the said exchange deed was his son, namely Uma Shankar Pradhan. Upon perusal of the said exchange deed, it can be ascertained that the defendant number 1, Shashabindu Pradhan, had signed on each page of the said exchange deed and as such, the allegation raised by him that he didn't go through the contents of the same does not hold any substance in the eye of law. A school teacher is an educated person, and it can be believed that such a person will execute a deed relating to landed properties, that too without going through the contents of the same. Furthermore, when his son also signed as an attesting witness, then the allegation of fraud is not at all believable. The next most important aspect of the suit is the action that an omission done by the defendants after plaintiff instituted the instant suit on 17/1/17. The defendant number 1, the title suit number 43 again against the defendant number 224 on 10
Sir,
to
Ghosh, give us half a minute. Mr. Ghosh, we find only one ground to appeal, admit the appeal, that is the appellate court, while reversing the judgment of the learned trial judge, did not advert to all the reasons, findings of the learned trial judge. That has not been adverted to. Gave his own reasons, order 6, rule 4, pleadings are not there, particulars are not there. Timidly said that collusive and all these things. But the reasoning of the trial court was sound, whichever way, right?
No,
Wrong,
and
we are not going.
evidence he has admitted each and everything that he or they are not students. First point.
Yes,
Second
that has
point.
not been adverted to by the.
No, nothing. Nothing has
We
been.
are admitting only on that ground, then we'll hear Ms. Mahit.
Yes.
Upon hearing learned counsel for the appellant, we admit the second appeal, which of the second appeal will be heard on the following substantial question of law. Whether the learned judge of the first appellate court committed a substantial error of law in reversing the decision of the learned trial judge without adverting to all the substantial findings and observations of the learned trial judge and stroke or the evidence, the total evidence on record. Push up. Next para. Yes, now you have asked for stay of that.
Yes. Because not my PM.
What would be the effect of stay of appeal?
Not preemption case will not proceed otherwise, and they will be dismissed.
But Mr. Ghosh, that will be allowing the relief before, because if you get an order in the preemption case, if we hold ultimately against you,
Your Lordship,
then that will create a problem.
So then your Lordship kindly, otherwise earlier occasion preemption case was dismissed with the liberty to file afresh. That has been filed again, depositing Lord 5 lakh and odd.
Understood, but if you grant a stay of the appellate court, then the trial court revives.
Lord, then your Lordship kindly said that will not affect the proceeding of that suit. In no final order may be passed. Pending the
preemption suit, we cannot pass an order here.
No, Lord, I have my prayer is that preemption case is pending. I have stated everything in the.
What is your prayer in this stay?
The petition, Lord, your Lordship kindly see.
Stay of operation would give you an undue advantage at this stage.
Yes, Lord,
before the appeal is heard out.
But in the facts, I have stated that misdeed.
You asked for stay of appeal. Stay would tantamount to allowing the, because if the appellate court says that the trial court decree is revived, the effect will be that suit will be held to be collusive, and this will be held to be a cell deed, and you get an order in the preemption, and then you lose the appeal subsequently. Then what happens?
But
it will be reversible.
But preemption case will go as soon as until and unless some observation is made that it will not be affected. Let it proceed, Lord, and no final order may be passed.
But we have not paid for anything of that.
Your Lordship kindly, even
with
this in this matter.
Ms. Maiti, what do you say?
Well, I was just wanted to submit to look into the judgment and order degree passed by the learned court below. That is learned civil judge, junior division, second court, Tonglu. Because this is the only court below where before whom two suits, that is case number 43 of 2017 and 9 of 2017, the two preemption cases all are filed before the same judge. So what I was going to submit, that whether a same court has any power to dismiss the judgment and degree passed by the passed by the self-same court, my lord. This was my first submission before your lordship. The self-same court, civil judge, junior division, second court,
Ms.
Tomlu.
Maithi, it is
all
the same court which has to pass. If a suit is filed challenging a decree on the ground of fraud or collusion, then it is the same court which has to do it, not a higher court.
But your lordship, my lord,
It's a
then your
different
lordship,
suit.
one document I shall place before your lordship, that is the judgment of Honorable Justice, my lord, Honorable High Court in civil order
So we
number
are not
6.
hearing the appeal finally. We have admitted the appeal, let it be heard on merits. But we are on the stay. But if the Mr. Ghosh is asking for stay, and we are of the opinion that if we grant a stay, then it will give an undue advantage to him in the preemption case. But the
Yes.
reverse is also true. If you don't say anything, then the preemption case will be dismissed tomorrow.
Well, I cannot be, I shall leave it to your lordship, my lord. Preemption case on the basis of the judgment and degree passed by the self-same court, my lord. That court will proceed with the preemption case, my lord. So your
We'll give you
lordship, my
liberty,
lord, what I
Mr.
am
Ghosh.
submitting before your lordship.
Mr. Ghosh will give you liberty to, in our order, we'll give you liberty to approach the preemption court asking for stay in view of the admission of the appeal. But otherwise, we don't have any power to grant any stay of the preemption proceeding. Learned.
Lord, it has been fixed for dismissal.
Oh.
The preemption case is fixed for dismissal. No, last occasion, as Mrs. Maithi, my lord, took time.
No, my lord, your lordship, my lord, granted time. Your I did not ask for.
We granted time.
No, no.
Ms.
Lord,
Maithi did not.
Ms. Maithi mentioned the matter on the following
No,
day.
we granted of
That,
ours.
yes, that 17 I will not be out. On 15th, it was date was fixed for dismissal.
The appellant has filed CAN 1 of 2024 seeking stay of operation of the impugned judgment and degree of the appellate court. However, we feel that if at this juncture the operation of the impugned judgment of the judgment and degree of the appellate court is stayed, the effect of the same would be to revive the judgment and decree of the trial court, the necessary fallout of which would be that the decree passed declaring the disputed deed to be null and void would stand set aside, and the said deed would stand declared as a sale deed, which might give an undue edge EDG to the appellant in his preemption case. Next para, however, the converse is also true, inasmuch as despite pendency of the present second appeal and admission of the same, if the preemption case is dismissed on the premise of the appellate court's order, the same would be detrimental to the interest of the appellant. As such, we dispose of CAN 1 of 2024. We'll stay the further proceeding. The dispose of CAN 1 of 2024 by molding the relief as made herein and staying all further proceedings in what is the preemption case? Which paragraph? At least it was stated, yes.
Yes.
All further proceedings in miscellaneous J case number 1.
Yes.
Miscellaneous judicial case number 01 of 2017.
No.
Not that.
Yes. 01, not that.
That is withdrawn.
What is the preemption case number? You said you have given the number. Yes, that is the number. Miscellaneous judicial case number. See paragraph 14 of your application.
Yes.
Miscellaneous judicial case number 01 of 2017. Pending civil judge junior division for second court.
Yes.
Yes, same court.
Pending before the learned civil judge bracket junior division second court at Tomlup, district Purbo Medinipur till disposal of the present appeal.
Don't mention the number. I think that is not.
Para 14.
No, that is not earlier. That was withdrawn. That was dismissed. No, that miscase number I have not. No, paragraph 15 has stated the application has pending, and in order the order of impugn in this appeal by passed by the learned court below is not stated. The miscellaneous case under.
তাহলে যেখানটা miscellaneous judicial pending before the such and such court বললাম miscellaneous judicial case নাম্বারটা কেটে দিয়ে তার জায়গায় ঢুকবে pending before the same court ওটা থাকবে
same court
থাকবে যে the application under section, the preemption application under section 8 of the West Bengal Land Reforms Act 1955, pending at the behest of the present appellant before the learned order, যেটা তারপর যা বলেছি তাই থাকবে। আর the appellant shall, in view of appearance of Ms. Maiti, you are appearing for all the defendants respondents?
No, only one. Defendant number one.
In view of the appearance of respondent number 1 through the learned through his learned advocate, service of notice of the appeal is dispensed with on the said respondent. The appellant shall deposit requisites for service of notice of the appeal on the respondent numbers 2, 3, and 4 within a week from date. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. The appellant shall prepare and file informal paper books without comparing with the records within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. The leave is granted to the parties to mention the appeal for inclusion in the list of the appropriate learned single judge having determination as and when the same is made ready for hearing.
As your lordship, we are grateful to your lordship.
Defect.
Yes, my lord, the stamp reporter has, my lord, noted whether the second appeal is at all maintainable or not. According to my lord, it is maintainable, my lord. Issue has already been decided by a coordinate bench of your lordship.
What is the coordinate judgment? Effect is that the appeal is dismissed.
Appeal is dismissed. Order 7, Rule 11 allowed. I preferred appeal. Suit dismissed. I prefer regular appeal. Title appeal.
Wait. Not so fast.
I'm the plaintiff. Defendant number 4 had filed an application under Order
711. Yes, that was allowed.
My suit was rejected. Plaint was rejected. Now, challenging that, I filed a regular title appeal before the learned district judge. My lord, learned district judge affirmed the order of the learned trial court.
Dismissing the appeal.
Dismissing the appeal. Suit. And my lord,
rather rejecting the plaint.
And now, my lord, the second appeal has been filed.
The rejection of, ultimately it's a rejection of the, no, the question is whether, why has the report been given? Because it was dismissed under order for Rule 11. Probably for that.
No, whether, my lord, the second appeal itself is maintainable. That is the, my lord,
yes, second appeal is maintainable because, probably because the first appeal, the title appeal was dismissed at the order for Rule 11 stage. Probably for that reason.
My lord, no, it was a contested, my lord.
Order for Rule 11. Come to the judgment of the title appeal, otherwise is obviously maintainable.
Yes, this was dismissed under Order 41, Rule 11. My lord, court has held that, my lord, since the application, my lord, was under Section 11, that is an interlocutory order. Therefore, my lord, the title appeal is not maintainable. My lord, I tell your lordship, my lord, why it was done. My lord, kindly see my application. Has to be remanded to the appellate court. Kindly, what
give a notice to the other side,
yes,
will hear.
Why, my lord, I'll show to your lordship. Kindly see my can one. Why, my lord, what prompted, my lord, the learned trial appellate court to, my lord, come to that finding? Kindly comes to page 31. My lord, their defendant numbers 4's point was, my lord, there was an earlier suit, therefore the present suit is barred by res judicata. My lord, kindly see the heading. This is an petition under Section 11. My lord, and that is the prayer also.
Plaint has been rejected.
It has been rejected. Milord, that's why, Milord, the learned appellate court says this is for
This judgment is for what proposition?
Milord, second appeal is maintainable, Milord.
Against what? 7-11 rejection by both courts.
Yes.
So that we are order for 11 stage also same.
Ultimate effect is the same.
You serve copies of the application as well as the memo
Yes.
on the respondent.
Yes. This
We'll
has to be
treat that to be a
demanded.
notice of the appeal and we'll direct that the appeal and the application will be heard together.
But kindly do not relegate me to the single bench, Milord, after admission.
Why?
And for the
Which
next
single bench are you apprehensive of?
any single bench, but the time. And for the next 5 years, Milord,
Tell us the bench, we'll have a talk with the bench so that
I am not. Kindly do not relegate to me as a single bench.
no. At the admission stage, we are. Let us see whether the other side may not agree. But it has to be relegated to the.
Kindly do not, Milord. Milord, this is
The this is appearing under order 41.
41.
We find from the report of the stamp reporter that it has been doubted whether a second appeal lies, which of however, despite the title appeal having been dismissed as under order 41 rule 11 of the Code of Civil Procedure, the effect is that the same tantamounts to the title appeal being dismissed, thereby affirming the judgment and degree of the trial court and as such qualifies for being appealable under section 100 of the Code of Civil Procedure. Next para. Insofar as the other aspect of the matter is concerned, since the appellate court affirmed the rejection of plaint by the learned trial judge, which is a deemed decree within the definition of section 2 of the Code of Civil Procedure, it is a second appeal which lies against the judgment and degree of the first appellate court. Accordingly, we gloss over the said report of the stamp reporter and find that the appeal does not suffer from any defect on such count. Next para. The appeal, when the appeal is taken up for hearing under order 41 rule 11 of the Code of Civil Procedure, we find that the appeal is on an extremely limited point as to whether the, then we have to formulate the question.
Whatever.
As to whether the first appellate court was justified in dismissing the title appeal on the premise that the challenge was levied against an interlocutory order, by overlooking the effect of section 2 of the Code of Civil Procedure, which confers the status of a decree on a rejection of plaint under order 7 rule 11 of the Code of Civil Procedure, by erroneously going by the caption of the said application and not looking into the contents of the same. Next para. We are of the opinion that in view of the above, the appeal itself can be disposed of at the admission hearing stage, Hence, we stop short of admitting the appeal at this stage and direct the appellants to serve copies of the memorandum as well as the application on the respondents, indicating that the appeal shall be listed under the same heading along with the connected application on March 10, 2025, when the appellants shall file an affidavit of service to that effect. It shall be deemed that the service of copies of the application shall be construed to be a service of notice of the appeal on the respondents as well. The records need not be called for at this juncture. Formal preparation of paper books are also dispensed with. Whatever that means. Order 41 heading has been returnable data.
But the application was filed only by defendant number 4. May I serve upon him or all the Milord defendants?
All, it will have effect on all, serve on all. Great.
May it please your lordship, this is my appeal.
Lordship,
Well,
the
this-
draft of the respondent.
this
So,
my lord
Lordship,
appeal-
subject to your Lordship approval, can I pray for not this week's? Since I could not get ready. on
This
Wednesday.
appeal against what? Injunction order?
Injunction dismissed. My injunction petition dismissed upon final hearing. Initially, when I moved the injunction application,
But actually, immediately after admission, admission is virtually automatic, but immediately after that, you have to hear the application. So let us grant him time, because unless he is ready, no useful
Obliged.
purpose will be
meeting,
served.
my lord, I'll indicate the before the learned court below. The matter is on 3rd of March. Before that, I think because it has been dismissed only on the ground of maintainability of the suit. And the,
No, we are today only on 18th. So he asked
Anyway.
for time till 24th.
Only.
Oh, well, I'm led by Mr. Chatterjee, my lord. Thank you.
Then no time will be granted.
Lordship.
Yes, Mr. Chatterjee, what is
My
it?
lord, your lordship hasn't seen me.
What is the matter about Mr. Chatterjee?
My lord hasn't seen me at all.
On the prayer of the respondent,
After hearing the appellant on the prayer of the respondent.
on the prayer of the respondent, the matter is adjourned till February 24, 2025.
Right. In the meantime, they will not, I'm sure, for 10 years, there was an interim order.
Injunction has been refused.
After there was an order for 10.
There was.
Lordship, with due respect, subject to your Lordship, obviously kind
If you
consideration.
say due respect, there is no respect due.
Lordship, what my landlord senior friend, today I have paid for accommodation.
I
My
mean,
landlord friend through its
What was the
advocacy,
injunction which was refused?
my landlord senior friend with all due respect to my landlord.
Don't
senior
do
friend.
anything.
The Lordship,
Don't
he
do
is trying
anything
to
in
get an interim order without get the matter heard.
I'm not.
In the garb of that.
We are not granting it, but don't do anything.
Lordship, within Monday, nothing will happen.
Monday, that 24th. No, keeps it on the 26th.
Why?
24th and 25th in Jalpaiguri, my lord.
26th, where to 26th? 26th to take up the appellate side matters in
Let
the
it be
second
the
half.
list, my lord, whenever it's taken up, my lord.
Very well. তাহলে 24th না করলে 26 করে।
Obliged. With your Lordship.
Agree.
Obliged.
এটা তো আগেরটাই রয়ে গেছে বলে।
38, my lord, in this matter, my lord, I am appealing for the defendant appellant. Appellant is directed against the order of remand. Trial court dismissed the suit. Appeal court remanded the matter.
Mr. Rai, there is no caveat in the matter.
My lord, no.
Period. Against a remand order.
Here's the remand. Order 40/24.
What is your ground of challenge? Just tell us.
If your lordship kindly consider, the trial court dismissed the suit on twofold grounds.
Yes.
That the documents based on which the plaintiff is claiming title that Solomon degree no existence could be found either from the court below in spite of their direction.
Sorry, please repeat. The document.
The plaintiff's claiming title from his decree, Solomon degree passed in a particular suit. The existence of suit was doubted. Apart from that, we have also raised a question, even if that Solomon degree exists, without registration of the said Solomon degree does not confer any title in respect of the parties because it is a transfer of the immovable properties. Be as it may, trial court disbelieved their case and found that the existence of Solomon degree could not be found in spite of best effort. There is direction from this honorable court also to find out the records. It says there is no existence of such records. On the basis of which, my lord, the learned trial court dismissed the suit.
They had filed title suit basically.
Basically title suit.
On the basis of that, on the strength of that. Suit is not found, suit was dismissed.
Dismissed. Apart from that, even if, my lord, it can be held that yes, Solomon degree was there.
Registration.
Registration.
They have not pleaded registration.
Registration not clearly admitted. Now, my lord, can you consider how the appeal courts are dealt with?
How?
If I am drawing lordship attention so far the portion appeal code internal page 6. Not even findings portion, my lord. If your lordship can turn to page 10.
Yes. Here the trial court's findings are quoted.
Page 10, appeals court page 10, argument on the basic grounds.
No, where?
My lord, subsequently, my lord, the trial court judgment has been filed. My lord, whether it is.
No. আচ্ছা আচ্ছা
My lord, got it.
Yes, this is the memo.
Yes, in that appeal
Court
court judgment is there.
The appeal court judgment is 23rd September 22.
Yes, substitution. Yes. 23rd September 2022.
Internal page 10 of that. Page 10 of 22.
Yes, my
It's
lord.
written at the top 10 by 22.
10 by 22.
Yes. So, acha, very well. These are the grounds.
Grounds, my lord.
All right.
Now, my lord, can you turn to the findings, the point number 1, 2, and 3, it starts on page 12.
Yes.
I'm drawing lots of attention. So for the
sole degree is Solenama degree.
Yes, sole degree. Sole.
Yes.
Yes, being respondent defendants. Next page, first paragraph. Respondent defendants through their power of attorney holder, Polish Karmakar favored writ petition such and such. In the year 2008, they were praying for a writ in the nature of mandamus for a direction against the judge in charge such and such for supplying the certificate copy of the sole degree dated such and such in connection with partition suit number 37 of 1954. The order of the High Court dated such and such was marked Exhibit P. For it appears, Honorable Court observed the report of register visits that the entire record was destroyed. However, permission was given to the petitioner to seek assistance of the learned register for any information. Final letter being such and such, issued by the learned distribution, it appears the learned distribution stated existence of filing of title suit was not confirmed. In spite of that, my lord, can you turn to
Page 15, several events have been narrated.
Yes.
Probably to indicate that that Solenama degree with parties acted on the basis of
on the basis of, because my lord, the original property belongs to one.
So assume that there was a Solenama degree and on the basis of which parties have acted.
It is a appeals court view. Appeals court view. Lokhinarayan Pandey was the original owner. He died in the year 1954, leaving behind mother and the wife. The case made out by the plaintiff is that the wife Shitoprabha was forcibly driven out from the property, and mother used to look after the property and took charge of the entire thing. Subsequently, the Shitoprabha filed a suit. That is the suit which is in respect of which the Solenama degree was passed. In such a suit, my lord, it was agreed that the Shitoprabha will get the entire property after death of her the mother-in-law. And mother-in-law will enjoy the life estate. But the existence of that deed was not there. Now, my lord, after the death of the father, son, my lord, the mother being the class 1 years after 1956, whether he can inherit the property of its own, my lord, even if, my lord, can you consider in that way also. Even if, my lord, the Solenama degree says that the mother will get the life estate, whether, my lord, in the subsequently after 1956, whether this life estate to be restricted or it will turn to a culminating in the title over the property. Be as it may, I am not on that also. Whether the existence of that degree is also doubted. And apart from that, whether the Solenama degree without any registration, because the, my lord, today the partition suit, my lord, if your lordship
Solenama degree of, was of which year?
1956. The Solenama degree was passed, my lord, according to the plaintiff case, it was passed sometimes in 1959. That is prior to that, my lord is thinking some of those section 14.
No, but I mean, if they file the suit after so many years, obviously the degree may not be found.
There is existence is
doubted, yes. Nothing
existence is doubted.
No, why did the appeal court remand it?
Yes, my lord, can you turn to the point on basis of which the appeal court remanded the matter?
What was the logic of this? Yes, we are seeing that take evidence on point of execution of deed of gift and on to show that that Solenama degree was acted upon.
Acted upon. Apart from that, my lord, can you consider how it was held? My lord, can you turn to page 18, internal page 18 of.
Yes.
After perusing a series of deed, my lord, got it. Shitoprabha on and from 1983 to it can presume that after death of her mother-in-law, Shitoprabha started exercising her power as owner. It also remained silent during the period 83 to 2007. It can be presumed that the defendant and respondent knew about the sole degree and its significance. Moreover, Bimala Sundari never transferred any land nor exercised his ownership in respect to any plot of pension in the sole degree or in schedule of the plaint. The dispute between the parties cropped up after Sitaprabha died in the year 2005. So this was the finding for the existence of a degree which was the subject matter. Now can I turn to page 20. The sole degree cannot be treated as a composition deed, and it cannot be termed as family agreement. When the brothers of the mother-in-law were the main person behind the disturbance in possession, the suit was filed for recovery of possession and subsequently same was settled as the apparent from sole degree. From where the learned appeal court came to the finding on the ground, my lord, the kindly
So actually, the appellate court found that
existence of sole degree.
Not only existence of sole degree, but also that no execution was, no registration was required.
No, that is the subsequent one. Pause here for a moment and apropos to this, my can turn to page 3. What was the case made out regarding the sole degree?
Yes.
If your lordship can turn to page 3 from the top. The title suit before Sub-Judge Baharampur. The suit was registered Partition suit number 37 of 54. Subsequently, the intervention of some well-wisher, the suit was compromised and such and such. After hearing on sole petition, passed a degree in terms of condition of the degree. So it is not a suit for recovery of possession, it is simply seated. It is a suit for partition between Sitaprabha and Sarla. The appeal court comes with a finding that as if a suit for recovery of possession, so does not require any registration.
No question. Recovery rights were created.
Right. No, appeal court is of the opinion, my lord.
Appeal court does the appeal court say that no registration is required?
Yes. After that, my lord, the solidity cannot be page 20, my lord. Can you turn to page
20?
Familiation with the brothers and mother-in-law, main persons behind the disturbance position. The suit was filed for recovery of position, and subsequently same was settled as is apparent from sole degree. The instance in which the janitor did not or could not appreciate the evidence, and after that, page 21, your lordship find.
But there is no deduction in clear terms how the court arrived at the finding that sole degree could be deduced from the documents on record.
The document is doubted. The existence of documents is doubted.
No. What is the remand for? I mean,
remand for only for this purpose, if your lordship can consider.
Direction to frame additional issues regarding what? The acquisition of title by
acquisition of Bimala Sundari.
Bimala Sundari was the
mother
who executed the sole I mean,
who was one of the parties to the sole
Very well. You have thought for a stay also.
Yes, my lord.
The appeal will be heard on the grounds taken in the memorandum of appeal, particularly in the context of whether the learned appellate judge was justified in remanding the matter to the trial court on issues not germane for the adjudication of the suit, instead of deciding the appeal itself, since sufficient materials were available before the appellate judge to dispose of the appeal within the contemplation of Order 41, Rule 24 of the Code of Civil Procedure. Who's up next para? In view of a prima facie case having been made out for hearing of the appeal, the all further proceedings in connection with where is the application? Yeah. Section 5 was allowed previously.
Yes, yes. Section
all further
title suit number 26.
Yes, in connection with title suit number 26 of 2010, pending before the learned civil judge, Junior Division, Additional Court at Lalbagh, District Murshidabad, after remand, shall remain stayed till disposal of the application. Push of the appellants shall serve copies of the application on the respondents, plaintiff stroke respondent stroke opposite party numbers 1 to 3, indicating that the application shall next be listed on March 10, 2025, when an affidavit of service to that effect shall be filed by the appellant. Push of service of copies of the application on the pro forma respondent numbers 4 to 9 is dispensed with. What?
I am for the petitioner, Mr. Ranjan Kali appearing in this matter. He is appearing on court number 18.
On the prayer of the appellant, the matter is adjourned for the day. Come back tomorrow.
Number 40.
Item 40, Your Lordship, I am for the petitioner. Lordship, Sanjay Mukherjee appearing in this matter is currently arguing a matter before court number 17.
Yes, what do you say?
Your Lordship,
Sorry, my lord.
No, no.
My appeal, my lord.
Yes. Appeal against?
Appeal against.
I am for the, I have not right to audience. The suit value is 61,000. So, my respectful submission.
61,000.
Yes.
This is against what? Injunction?
This is against mandatory injunction.
No, but do you have jurisdiction or do you have to go with the district judge? 1,50,000 probably.
I think
1,50,000.
I have to go back to the district judge.
Yes, yes, right.
In fact, when I was reading it right now, I was reading
Yes, learned counsel for the respondents rightly contends that the appeal is not maintainable before this court, full stop. Learned counsel for the appellants, comma, in his usual fairness, comma, concedes to the proposition that in view of the valuation of the suit from which the present appeal arises, comma, the appeal, this court does not have jurisdiction to entertain the appeal, full stop. Accordingly, FMAT 380 of 2024, as well as the connected applications, bearing can 1 of 2024 are dismissed as not maintainable due to lack of pecuniary jurisdiction, full stop, comma, with liberty to the appellants to approach before the appropriate court with an appeal against the self-same impugned order. Full stop. There will be no arrest to cost. Leave is granted to the learned advocate and record for the appellants to take back the certified copy of the impugned order upon furnishing a proper photocopy of the same for the records.
I'm obliged, my lord.
Number 41.
May it please, Your Lordship.
My lord, I am for the respondent number 1, my lord, plaintiff.
Yes.
My lord, on last occasion, my lord, I had placed the
May
fact.
I, my lord, make a small submission, my lord. I'm led by Mr. Surojit Mitra, my lord. He is on legs. But if your lordship so desire, my lord, your lordship, my lord.
We have 12 minutes. He will
Yes.
take 12 minutes.
Yes, yes.
Little more, in fact, my lord.
Maybe more.
If I was placing the impugned order, Lordships, if Lordships kindly take the last volume, my lord, Mr. application.
Last order. Our last order.
Last volume, my lord. No.
Last volume. Sorry.
Volume 4, sorry, my lord. Volume 4 starts at page 439, my lords.
Yes.
Lord, at 564 is the impugned order, my lord.
Yes.
Lord, if Lordship, my lord, permits me, my lord, I can start from the beginning, my lord, though, my lord, I had placed up till 465.
No, you can start from there because in any event, we won't be finishing today.
So then I'll place the entirety of the order. Or Lordship.
So need not, it will start again on the next day.
My lord. If Lordship kindly turns to page 566, my lord.
Yes.
Lord, I was on page 566. Lordships.
Probably this is the first order 41 matter where we will take written notes. Because of the loss of continuity and not for any other reason.
No, my
Yes.
lords, for your Lordship's convenience on last occasion, Lordships, I was.
You had given something.
My lord, we handed over a list of dates. my
List
lord.
of dates, yes.
List of dates. Possibly that also.
That
might-
would suffice.
That
Very.
should suffice, my lord.
Very.
That should.
Very.
Hopefully. Because, my lord, what I have done, my lord, in the list of dates, my lord, I have earmarked the page numbers as well. Page
Thank you,
numbers
thank you,
also.
thank you. Yes, yes.
So that may be of some assistance to Lordship. Lord, but these.
Yes.
থাকলে আমি নিশ্চয়ই দেবো কেন দেবো
What is he saying?
But he's asking for another copy, my lord. On last date, I was means
So don't
I
give
had
another.
served it to them.
You have already given copy, don't give another.
No, my lord. That will be my lord, outside the court, my lord.
Yes.
Lordship, defendant number 2 by filing. Now, Lordship, defendant number 2 by filing written objection has submitted that. Now, Lordship will kindly take what are the points which I had taken. And Lordships will kindly bear this in mind. Lord, I was the only one who filed written objection. Nobody else. None of the other defendants filed written objection. But maybe 2 or 3 groups, my lord, they filed some written submission, notes of arguments. But no written objection filed by anyone. The present suit is barred by Section 80 of the Code of Civil Procedure. Lordship will recollect, my lord, I said because the government additional district sub-registrar was a party, my lord. So that is why, my lord, I had taken the point of maintainability of the suit on being barred under Section 80, my lords. Now, ground number 2, my lords. It is a submission of the defendant that the plaintiff deliberately has suppressed the fact that the defendant number 2 had instituted a writ petition being number so and so before the Honorable High Court at Calcutta, wherein the plaintiff was respondent number 12, and that the Honorable High Court, while disposing of the aforesaid writ petition, granted liberty to this defendant to file suit before a competent court of law and seek remedy as was prayed for by defendant number 2 in the said writ petition. The ex parte ad interim order of injunction granted by this court, my lord will kindly mark this, is in direct contradiction to the order passed by the Honorable High Court in the said writ petition numbers dated so and so. Then, my lord, number 3. The plaintiff fraudulently and illegally has tried to give an impression that he still has right and claim an interest in the Bishwanath Ganeriwala HUF, knowing the same to be false and thereby has committed an act of perjury. Plaintiff all throughout was aware about the family settlement and partition entered into by and between the parties through the settlement and partition deed dated 2nd of December 2008, with which the parties had distributed, allocated, divided and demarcated their respective entitlement in respect of the properties left behind by late Bishwanath Ganeriwala, which came to be the Hindu undivided family by virtue of the will left by late Bishwanath Ganeriwala. In fact, the plaintiff, by way of a purported letter dated 6/7, my lord, lordship will recollect, my lord, I had placed that letter, my lord, which he had suppressed.
Yes,
the plaintiff had suppressed, my lord. Issued to the defendant number 25, i.e. the ADSR Alipur, clearly admitted that he was a party to the aforesaid settlement and partition deed dated so and so, but alleged that the deed has been manipulated and or interpolated, and for the alleged reason requested the defendant number 25 not to complete the registration of such deed and sought cancellation of the same, which fact has been fraudulently suppressed by the plaintiff in the present suit. 4. As per the submission of the plaintiff, the alleged cause of action to institute the present suit for the first time arose on 1st of December 2023, when the plaintiff allegedly came to learn about the partition deed and settlement dated 2nd of December 2008 for the first time. But the said allegation of the plaintiff on the face of it appears to be false from the purported letter dated 6th of July 2023, issued by him to the defendant number 25 as referred to above, my lords. The defendant number 2 submits that this court has no jurisdiction. Lordship will kindly mark this. The defendant number 2 submits that this court has no jurisdiction over any of the properties mentioned in the schedule of the plaint as also the injunction application. My lord, I had never ever contended, my lord, that the learned court lacked jurisdiction with regard to trying the deed in question. Or that was not my lord, the submission or my point taken by me.
Regarding the injunction.
My lord, I said, my lord, none of the properties described in the schedule form part. None of the properties. Lordship will recollect, my lord, I demonstrated my 3 properties, all outside. Number 6. He further submits that the plaintiff has deliberately suppressed the very fact that the Hindu undivided family of the defendant number 2 has filed a suit before the learned Bombay City Civil Court at Borivali subdivision at Dindoshi, being suit number so and so, seeking declaration and injunction in respect of its property being land measuring so and so metered together with the basement plus ground plus 3-story building lying and situated R154 Juhu Tara Road, Mumbai so and so. Plaintiff has obtained the details. Lordship will kindly mark this because, my lord, I had put him to strict proof as to from where he got the details which he had mentioned in the schedule of Mumbai property. Because, my lord, he could not have got it save and except, my lord, the schedule mentioned in my suit in the file before the London City Civil Court at Mumbai. The plaintiff has obtained the details of the property described in Schedule A to the plaint as also in the present injunction application from the plaint filed by the HUF of the defendant number 2 in suit number so and so. Plaintiff did not have the details of the Mumbai property before he came across a copy of the plaint filed in the aforesaid suit. The plaintiff in collusion and conspiracy with defendant numbers 1, 3 to 6 and 14 to 22 has filed the present suit, which would be evident from the stand taken by such defendants in the instant suit as well as in title suit number 423 of 2023 pending before this court. By suppressing all the material facts, the plaintiff has perpetrated fraud upon this court and thus deserves to be dealt with accordingly. The defendant number 2 has stated that he is the eldest son of Vishwanath Ganeriwala and resides with his family at so-and-so. He is the Karta of Messrs. Pradeep Kumar Ganeriwala HUF, and through the said entity, he carries business activities. The defendant number 2 claims that he is also the Karta of Vishwanath Ganeriwala HUF. Lordship, just pausing here for a moment. My lord, this was my stand, my lord. I said that after, my lord, the deed of 2008, my lord, was executed by and between the parties, my lord. Because, my lord, that deed contemplates and it is agreed between the parties, my lord, that Vishwanath Ganeriwala HUF ceased to exist. No, it is a stand, my lord, and case being run by the appellant before your lordship, my lord, that I and my branch of family, my lord, we continued with Vishwanath Ganeriwala HUF. So, my lord, I am having 2 HUFs, my lord. One, my lord, in my own name, my lord, that is Pradeep Kumar Ganeriwala HUF, and the second one, Vishwanath Ganeriwala HUF, my lord. Admitting the devolution of various immovable and movable properties of late Vishwanath Ganeriwala after the death of his, in terms of his last will and testament upon Mrs. Vishwanath Ganeriwala HUF, the defendant number 2 has stated that after the death of Vishwanath Ganeriwala, defendant number 2 being the eldest male member of the family and as per desire of the Vishwanath Ganeriwala became the Karta of said Mrs. Vishwanath Ganeriwala HUF. He and defendant number 3 being the 2 named executors to the aforesaid will of late Vishwanath Ganeriwala dated so-and-so applied for probate of the aforesaid will dated so-and-so before the learned district delegate at Alipur, Vide probate case number so-and-so and the learned district delegate Alipur granted probate of the aforesaid will by an order dated so-and-so. Late Vishwanath Ganeriwala was a successful businessman who during his lifetime acquired and or built numerous assets and or properties. The said Vishwanath Ganeriwala during his lifetime, apart from having made investments and or acquiring numerous immovable properties, had also made investments in banks, shares and securities, gold and jewelry, and or created interest and or entered into agreement for numerous properties. One of such property in which late Vishwanath Ganeriwala during his lifetime had created an interest was a bungalow at premises number R154 Juhu Beach at Mumbai. Vishwanath Ganeriwala, since deceased, for self and as or Karta of Messrs. Vishwanath Ganeriwala HUF during his lifetime, had participated in an auction proceeding conducted by Honorable High Court at Calcutta in connection with matter number 779 of 1986 for purchase of property being bungalow at premises number R154 Juhu Tara Road at Mumbai. Lordship, I am just pausing here. My lord, I had never said because Lordship will recollect when the order said R154 Juhu Beach.
Yes.
It came to be numbered later, renumbered and renamed later. Well, I never said that he participated in R154 Juhu Tara Road. He participated in R154 Juhu Beach. The Honorable Court, by an order dated 8th of August 1986, passed in the matter number so-and-so, was pleased to accept the offer of late Vishwanath Ganeriwala since deceased and confirmed the sale in his favor. The Commissioner Sanchayata Investment, who was appointed as a Commissioner in respect of properties of Sanchayata Investment by an order of Honorable Supreme Court of India in furtherance of order dated 8th of August 1986, passed by the Honorable Division Bench of Honorable High Court at Calcutta, a sale certificate was issued in favor of Vishwanath Ganeriwala HUF. The said Vishwanath Ganeriwala was then the Karta of Messrs. Vishwanath Ganeriwala HUF. In this connection, the defendant number 2 mentions that the aforesaid sale certificate was never registered. Lordship will kindly mark this. The sale certificate was never ever registered, my lord. In the meantime, Vishwanath Ganeriwala died on 3rd of August 1994, leaving behind the aforesaid will and testament. The defendant number 2, who became the Karta of the then Vishwanath Ganeriwala HUF, alone was looking after and managing the aforesaid property at Mumbai. The said Vishwanath Ganeriwala having died prior to registration of the aforesaid property at Mumbai, the then co-parsonage of the then Vishwanath Ganeriwala HUF sometime on or about, that's blank, decided and agreed that the property at Mumbai, aforesaid property at Mumbai should be mutated only, my lord will kindly mark this, should be mutated only in the name of defendant number 2. In pursuance of the same, the defendant numbers 1, 3 to 6 affirmed an affidavit before the notary public at Calcutta on 18th of August 1998, which affidavit was filed before the Honorable High Court at Calcutta in so-and-so, by which the deponents of the said affidavit inter alia declared that they had no objection and gave consent for mutation of the aforesaid property at Mumbai in the name of the defendant number 2.
They're saying that immediately will rise, but we won't. Please continue.
No, as per your lordship. my
No,
lord.
continue at least till the end
This
of the paragraph. Let us prove them wrong outside the court.
The Honorable Division Bench of the Honorable High Court at Calcutta entirely are taking into consideration the aforesaid affidavit. Lordship will kindly mark this. I'll place this order, my lord. Order dated 1st of March 1999 was pleased to direct inter alia the Municipal Authority of Mumbai to give effect to the sale certificate issued by the Sanchayata Commissioner and to make necessary mutation of the aforesaid property at Mumbai in the name of the defendant number 2 in accordance with law. Lordship will kindly mark this. In accordance with law, after giving an opportunity of hearing to all the interested parties. So, my lord, if anybody had any sort of objection, my lord, they were given ample opportunity, my lord, at the then point of time, my lord, to raise their objection, my lord. Defendant number 2 thereafter tried to get the aforesaid property at Mumbai mutated in his and or in the name of his Hindu undivided family in the records of concerned municipal authority. However, the municipal authority refused to mutate the property in the name of the Hindu undivided family of the defendant number 2 and or delayed, stating that there was no registered instrument existing or subsisting in favor of defendant number 2 or his Hindu undivided family which conferred the title of the aforesaid property unto the defendant number 2 or his HUF, my lords.
Let us stop here. We'll continue from here. Award we heard in part, for further hearing tomorrow.
Grateful, lords. Thank you.